Airport information mic. Wind at 320 degrees at 6, temperature 53, altimeter 3000. ILS approach runway 260. Cheers, contact clears delivery on 125.3 before taxi. Firm radar service frequency. Advise if transponder equipped. Inform the controller of initial contact that you have received information mic.
Hi everyone, good afternoon, welcome to all. Welcome to the International Workshop on Laws Governing Aviation in India, our initiative in collaboration with Campus Law Center, University of Delhi. Yesterday we had an interesting rundown, we had an interesting panel who spoke about academic social responsibility, and that responsibility we continue with even today. And of course, the objectives of the event, the workshop, are to provide students with an early foundation of the aviation legal framework, not only in India, but also abroad, so that they can apply this knowledge with the industry academia connect. And we wish to encourage wider adoption of industry-centric course streams by universities and law colleges. So as I was saying that we had an interesting lineup yesterday where Mr. Amber Dubey, the Joint Secretary MOCA, spoke about drones regulation in India. What was the perspective being national importance and public interest? Then we had Ms. Vandana Agarwal speaking about the overall aviation ecosystem. She spoke about how the aviation sector had been hurt, the worst hurt. She brought about the positives about the industry in terms of double-digit growth. She spoke about cargo coming up, freighter operations being picked up for distribution of vaccinations and vaccines. She spoke about Vande Bharat schemes, the calibrated operation of domestic airlines, MRO, air cargo policy, and ultimately recognized the work which had been put in by the aviation personnel as well to bring everything together. Then we had, of course, our managing partner, Mr. Sharma, who brought with himself, the history and evolution of aviation laws in India, with the objective that we should have our foundations well built. Then we had, of course, Mr. Reddy, who is a professor with NALSA, one of the renowned universities in India, who run master courses for aviation laws in India. He spoke about conventions, Warsaw Convention, Montreal Convention, the Chicago Convention. He gave a new term, and a key takeaway from that session was, of course, ASR and PPP, public, private, and penal law for air safety. And lastly, we had Professor Trussell from Leiden University, who gave us an insight into, the Chicago Convention and his perspective on it. Now we move on to day two. And the agenda today is more on the business side. We will delve into aircraft leasing, various structures involved, governing law and jurisdiction, redelivery, repossession. We'll deal with aircraft fleet acquisition, which are normally known as aircraft purchase transactions, whether one should consider purchasing a new aircraft versus a used aircraft. We will have, an overall industry perspective. What are the practical aspects of leasing and financing transactions? The impact that COVID and the pandemic have had on the industry in the last 2 years, and where we are progressing after the pandemic. Lastly, we will delve more into the Cape Town Convention, its applicability, adoption, and status. And we will have our managing partner release the handbook on leasing. Now, of course, we have an equally interesting lineup for today, and good morning to our friends who are joining from London quite early in the morning today. So we have Richard Hicks from, Reed Smith, which is a well-recognized, internationally renowned law firm. And he's supported by his team today, Andrew Harper, who's a senior associate, Ashley Standen, and Rohan Soni, who both have, Ashley has experience of more than 10 years, and Rohan has experience of more than 6 years. dealing with international transactions. Coming back to Richard, Richard is the chair of Reed Smith's Transportation Industry Group. He's an asset finance partner specializing in shipping and aviation. He advises clients in relation to a lot of broad range of aviation and shipping work, with primary focus on financing, leasing, trading, repackaging of transportation assets. He acts for clients across the whole spectrum and life cycle of shipping and aviation deals. He's advised lenders, equity investors, leasing companies, operators on a wide range of aircraft, both narrow body and wide body aircraft. He advises on maritime law, other asset-based and receivables-backed finance and leasing transactions. He also has extensive experience in a wide range of structured and large-scale cross-border transactions, including export credit agency-related matters, commercial debt finance, Islamic finance, Japanese operating leases, tax lease structures, PDP finance, normally known as pre-delivery payment finance, operating leases, individual asset and portfolio sales and purchases, securitizations, capital markets, and so forth. Over to you, Richard. I think the board is to you, and I hand it over to you.
Thank you, Kashish. Hopefully everybody can hear me okay, and thank you for your kind words, and most importantly, thank you for your invitation to contribute to this workshop today. I don't think any further introduction is necessary after Kashish's wonderfully warm welcome, other than to say that both myself and the individuals in the room with me today were chosen for this presentation on the basis that not only are we all aviation lawyers and spend a significant amount of our practice working in the aviation space, but on the basis that we also have a very keen affinity for aviation leasing, and in particular for the beautiful country that is India, and all of the excitement and challenges that the Indian market offers. And I'm sitting here today in an unusually sunny London office. So if I appear to be squinting or dazzled, that is genuinely sunshine. It's rare over here, so we're excited. And I can see vapor trails from aircraft as they take off from London City Airport. And it gives me a really warm feeling that the markets are opening up again for the world of aviation, for the world of international travel. And to that end, I very much look forward to reconnecting in person with the legal team and no doubt with many others as well. In terms of what we're going to talk about today, really we will give you an overview of leasing as a whole. And we're going to break that up into a number of different components, partly so that you get to hear from everybody in the room, and partly to try and give you a sense of the shape of the aircraft lease. And so we'll talk in a minute about why one might lease aircraft. We'll have a look at the duration and some of the key terms of leasing. And we'll have a look at what happens once the aircraft has entered into the lease. So the delivery of the aircraft, the redelivery at the end, and what happens in the intervening time, the operation, the maintenance, and insurance. We'll have a look at trading transfers. The ability to move aircraft around between lessors is something that's become increasingly pertinent. And we'll have a look at the additional lease documents as well, because the lease is what sits very much at the center of a leasing transaction, but is really only the primary document and is not something that exists in and of itself. We'll mention enforcement. It's important, it's topical, and I think it's fair to say that by volume, we are the number one practice globally for aviation work in the private equity sector. And so we have probably an unusually extensive amount of experience of enforcement from both sides of the table. And we'll finish up with a brief look at leasing and financing context before we also give an opportunity for questions. And I've told that the questions will all be very challenging and very difficult, So I'm thoroughly looking forward to my examination at the end of the session. So without further ado, why lease? And I think the important point to understand is really what is a lease. And there are really many different definitions of what a lease is, and there isn't a single accepted definition as a matter of English law or as a matter of New York law or Irish law. But really the best definition, in my view, is taken from the Cape Town Convention, which is an international treaty that governs security interests over aircraft and aircraft objects. And the Cape Town Convention talks about one party, the lessor, granting rights over an object in return for rental or some sort of other payment to another party, the lessee. And I think if you're looking for a succinct definition, to my mind, that is the most apt definition to use. There are others, and for those of you who enjoy reading case law, I would commend the case of Celestial Aviation Trading to you. You can enjoy Justice Hamblin's comments at your leisure. They're rather extensive and they go into some of the intricacies of what is leasing, but that is essentially the nature of a lease. Now, when you break that down further, there are various different types of lease, and really the way that we principally categorize it for these purposes, we'll look a little bit later at financing leases and operating leases, but really for these purposes, and as to why a party would lease an aircraft, the important point, the important distinction is whether the lease is a dry lease or a wet lease. And simplistically, the way I always think of this is that your dry lease is akin to your rental car, and your wet lease is akin to your taxi cab. Now, this is a simile that has some limitations, and we'll discuss those in a minute. But the dry lease is a lease for what we call a naked aircraft. It is for the metal. It doesn't come with anything else. And the lessee will assume the operational responsibility, will assume the responsibility for maintenance, for crewing, for insurance. Now that's important. The term is usually longer, I think probably at least 2 years. That's important because if you want to lease on a dry lease basis, then you need to have a longer term plan. You need to have a purpose for an aircraft for a period of 2 years or more. That would be a relatively short dry lease. And you need to have the infrastructure around it to enable you to operate that aircraft. In contrast, a wet lease, as I say, is a little bit more akin to a taxi. A wet lease will usually be provided with not only the aircraft, but also with the crew, with the maintenance, and with the insurance. So you'll sometimes hear a wet lease referred to as an ACME lease, being the acronym for aircraft, crew, maintenance, and insurance. Now, where my simile sort of runs out is that lessees will typically be responsible for fueling the aircraft under a wet lease and for landing charges. So clearly, at least in my experience, I've never been asked to put any gas in the tank of a taxi driver, and I hope that doesn't happen because I suspect my skill set is not best suited to doing that. But that is essentially what a wet lease is. Now, why would you wet lease an aircraft? Well, we've seen some really interesting examples recently, usually for seasonal extra lift capacity. So if you have a high season in one part of the world, you might bring an aircraft in on a short-term basis from another part of the world that is currently in a low season. We saw a lot of wet leasing during the COVID, the worst of the COVID situation, when the so-called belly cargo capacity, so the cargo capacity under your feet on aircraft, was obviously taken out of the global cargo freight system because passenger aircraft weren't flying. So freighters were being wet leased to provide extra short-term lift. And the other reason we see wet leasing is very topical. Russia, Belarus, Other nations have been on the tip of our tongue in relation to sanctions, and there are certain operators, particularly in the Middle East, where for historical reasons, it is very difficult to operate an aircraft into certain jurisdictions if they are registered in certain other jurisdictions. So wet leasing provides, in that sense, a certain operational flexibility. Looking at it, I suppose, from a slightly broader perspective, really why lease? Well, the fundamentals of leasing for a lessee, whether it's a wet lease or a dry lease, are very much around not taking a capital-intensive asset into their business. It enables the cost of acquisition, let's call it, to be defrayed over the period of that lease term. You pay for the aircraft essentially over its life. We'll talk a little bit more about that in the context of operating and finance leases later on. Also, it gives a certain flexibility to airlines. The lessors will go and invariably sign up large purchase contracts some significant period of time into the future. And at this stage, one doesn't know whether an aircraft type is going to be popular. And it also doesn't know whether the price is going to be favorable. And by popular, I don't just mean aesthetically desirable. I mean, will there be widespread support for a particular type of aircraft? And so for an airline operating a relatively small fleet in particular, there is a clear competitive strategic advantage to leasing and having that sort of nimble, flexible business model. So I think I'll leave that there, and let's delve a little bit more into some of the actual terms and key provisions of the lease. And I'll hand over to my colleague Andrew to walk you through some of those.
Thank you, Richard. So in terms of sort of the key financial terms that may come up in operating leases generally, we sort of categorize these as follows. I suppose sort of taking a step back in sort of the wider context, aircraft are often financed, and so financiers will often look at the terms of a lease and consider its bankability. So these will often be very key criteria that they will look at when sort of analysing the leases for the purposes of the financing. So sort of turning to the term of the lease, this can vary. We have seen between 5 and 12 years. Of late, I would probably say it's between the 10 to 12 year mark, but it will depend on where the aircraft is in its life cycle. The end of the lease is often coordinated to coincide with a maintenance event. And ordinarily, it would be rare to find a voluntary termination option for the lessee in that lease, but early termination is considered in certain scenarios. So, for example, if there's ever a total loss in respect to the aircraft, if there's ever an illegality event which might impact upon the ability of the lessor or the lessee to comply with its obligations under the lease, or I guess more commonly, if there is an event of default by the lessee under the lease. So turning to the security deposit, this is effectively, it's arguably a bit of a misnomer under English law when we talk of it as security, because it's designed effectively to be the unconditional property of the lessor. Once it is paid, they are then free to commingle it with their other assets. And what you then have at the end of the term in certain scenarios is a corresponding refund obligation upon the lessor to return an equivalent amount back to the lessee. And the nature of the security deposit, this can either be cash or a letter of credit covering anywhere between a month to 3 months rent, potentially depending on the commercial terms. In terms of the basic rent itself that's payable during the course of the lease, this is ordinarily payable monthly in advance. It can also take other forms, can be quarterly. From a financier's perspective, they would want to make sure that there is a regular flow of payments to sort of match any corresponding loan terms. So, for example, they wouldn't want to see any sort of lump upfront payments being made. In terms of the nature of the rent, it can take either a fixed or floating format, with LIBOR changes, of course. That used to be the reference point. That will have to sort of be updated to reflect changes in risk-free rates that are sort of commonly used in the market now. And if you do have a fixed rate lease, that has potential implications for a financing as well, in terms of any mismatch between that fixed rate coming from the lessee and then any floating interest rate obligations of the lessor/borrower under its financing. So there may need to be sort of hedging arrangements put in place to counter that. Perhaps more of a creature of the pandemic, I would say, is a tendency towards power by the hour payments. When so many aircraft have been grounded over the past couple of years, there's been a tendency to perhaps sweeten the deal with certain airlines to keep them on lease, to sort of change the parameters of the rental payments so that it is effectively dictated by the usage of the aircraft by that lessee in what is called sort of these power by the hour terms. And sort of touching on two sort of ancillary corollary points to sort of the rent, there is of course withholding tax issues that do crop up, and it's especially a key concern for Indian airlines I've encountered in the past. So effectively, when, say, an airline in India pays to a lessor in Ireland, say, there could be a withholding tax implication. If that were to arise, there would then be a contractual obligation upon the lessee to gross up its payment to that lessor. So what is often done then is to sort of try and structure the leases so that you are taking advantage of double taxation treaties between two different countries. So I think actually between India and Ireland, I think there is a favourable double taxation treaty in place, which does sort of minimise, if not completely eliminate, any withholding tax concerns that might arise. And hell and high water is again sort of a term of a lease which sort of goes to its core bankability, I would say. This is effectively an obligation upon the airline to pay in all circumstances, come what may. So even if there's been a total loss of the aircraft, they're still under an obligation to pay rent until the total loss payment has been made to the lessor. And this is to sort of to make sure that there is a regular and almost irrevocable flow of funds going to the lessor. So looking to maintenance, which is another sort of key financial area, the operation of an aircraft brings with it certain significant and expensive maintenance events during its lifetime. Broadly, these are sort of categorized in terms of sort of airframe checks, auxiliary power unit overhauls, landing gear overhauls, and with respect to the engines, you have a performance restoration, and also the sort of life-limited parts that are installed on the engines will need to be replaced over the life cycle of the aircraft. So this can be quite a significant financial exposure, which can be dealt with in two ways. One is to effectively have a regular payment of maintenance reserves, which are payable monthly during the lease term and assessed by reference to the usage of the aircraft over that period. Similar to the security deposit, this would be expressed to become the unconditional and absolute property of the lessor, that they're then free to commingle. This again can be done either by way of cash or a letter of credit, which is put up as security. And I guess one sort of interesting point that might arise with maintenance reserves is increasingly airlines might have a total care arrangement in terms of its engines with a manufacturer such as Rolls-Royce. And as a consequence, because they're effectively paying into their separate pot with Rolls-Royce, they would want to have their maintenance reserve obligation suspended during that time, which can then bring with it its own sort of implications for a lessor and financier, that they would want to have the ability to get access to that pot of cash whilst the maintenance reserves are suspended. So there can be sort of quite lengthy and difficult discussions, tripartite discussions between the airline, the relevant manufacturer and the lessor, and actually potentially even the financier putting in those arrangements. And sort of the alternative to maintenance reserves, which perhaps might be reserved for sort of better credit airlines, is an end of lease compensation. It's payable at the end of the term, so once the aircraft is at redelivery, and that would be calculated by reference, again, to the usage of the aircraft. But unlike maintenance reserves, which are sort of done on a monthly basis, this would be looking back over the period of the use of the aircraft, either from delivery or from its most recent maintenance event. So I think that sort of brings me to Ashley covering delivery and redelivery.
Thanks, Andrew. So these sound like very simple stages. It sounds like, you meet at the airport and you hand over the keys, but actually the delivery and the redelivery processes are critically important in the leasing process for both sides of the lease. It can require very, very detailed choreography as well. There will often be a specific time window for the delivery, starting at the beginning of the lease, and that can be subject to the delivery of the aircraft by the seller or the manufacturer to the owner, or the redelivery to the owner of the aircraft by the previous lessee. This can be quite tricky to organise, but the lessor will need to ensure that redelivery under one lease, or delivery from the seller, and delivery under the next line up to avoid having the aircraft on their insurance for even as a shorter period as overnight. Lessors will work very, very hard to avoid taking on that risk for even very short periods of time. If for some reason there is a delay in the agreed delivery period for the aircraft, there might be a grace period, there might not be. Depending on the circumstances of the incoming lessee, there might be a termination right agreed if the delay goes on for too long. There might be liquidated damages agreed or discounts to the rent. That will depend on the situation of the parties and whether or not the lease then goes ahead after that delay. The acceptance certificate, this is a very, very important piece of the puzzle in aircraft leasing. It's often just a single page document, but it can be subject to a surprising amount of negotiation and even litigation if things don't go well. A lessor will want a clean acceptance certificate, clean as far as possible, where the lessee very clearly states they've accepted the aircraft in the condition that it's in. And the lessee will want any discrepancies in the condition of the aircraft from the agreed condition of the aircraft to be itemised in that certificate and either resolved or compensated for. Some leases, of course, have as is, where is as their delivery condition. So it might be slightly different there, but no matter what, the parties will want to be very, very clear about what's in their acceptance certificate and that is signed and delivered appropriately at the right time. Then looking to the end of the lease period for redelivery of the aircraft, it's a similar process in reverse. There will be an agreed redelivery condition set out in the lease, or as is, where is, depending on what the parties have agreed. If the lessee fails to comply with the redelivery condition, there can be financial consequences to that, and that will probably be because the lessor has lined up either a follow-on lease or a sale of the aircraft, and they will have obligations that they need to meet under either that sale agreement or that lease agreement. If the outgoing lessee doesn't meet their obligations in terms of the redelivery condition, that will prevent the lessor then being able to meet their obligations under the next arrangement. So there might be an ability agreed for the lessor to claim as a debt or to claim any amounts of cash that it might be holding under the various arrangements that Andrew spoke about. There might be a letter of credit they can claim under, or amounts of the maintenance reserves that they can hold on to. So there should be some options agreed there in the lease. And the lessor may, not always, but may have provisions that allow them to force redelivery of the aircraft. Again, if they are under an obligation to sell the aircraft on by a certain time, for example, again, with the appropriate compensation, where this means that their obligations under the follow-on arrangement are affected. So, assuming the delivery goes ahead to plan, during the term of the lease, there will be various conditions to do with the operation of the aircraft that the lessee will have to work to. Various parameters will be in place, some of them commercial and some of them legal. For example, they will be required to operate the aircraft within the bounds of the insurance policy to which the aircraft is subject. They will have to comply with any applicable sanctions laws. There might be a requirement not to carry certain cargo, such as live animals, or certain chemical cargoes might not be permitted. They might need to keep within certain cycle limits or manufacturer tolerances, depending on maybe the jurisdiction in which they want to operate and the environmental conditions. They will also need to operate the aircraft without discrimination against other aircraft in their fleet, and that's particularly important where aircraft might be on power by the hour arrangements, again, as Andrew spoke about. That will be to make sure that the lessor gets the rent that it is expecting or hoping to receive. The lessee will also need to provide the lessor with the usual operational indemnity, so they will have to indemnify the lessor for any losses arising from their operation of the aircraft. These agreed parameters might also include restrictions on further leasing or subleasing by the lessee. Wet leasing will often be permitted, subject again to certain parameters, usually for quite a short period of time. For subleasing, more generally, that might require a lessor consent, and that might also need to reflect what the lessor is required to do under their financing, if there is financing in place. There will usually also be a restriction on subleasing individual items of equipment or the engines. That can depend on the creditworthiness of the lessee or the commercial agreement between the parties, a whole range of factors there. A lessee will normally receive what's called a quiet enjoyment right from the lessor, and often from the lessor's other interested parties, such as their lender or their security trustee, who might have a mortgage over the aircraft. That quiet enjoyment right will usually be switched off if the lessee becomes in default under the lease. That might be able to be remedied, it might not, but that's something there to be aware of.
And sorry to interrupt, Ash, but so just to explain, the quiet enjoyment right essentially says if the lessee of the aircraft has not done anything wrong, then it doesn't matter that its lessor may be in default, for example, under its financing arrangements. If that lessee is in conformity with its lease obligations, then during that currency, it is entitled to continue to enjoy the quiet enjoyment and use and possession of the aircraft. So in other words, it's a way of ensuring that as a lessee, you are protected if you allow your lessor to go and finance the acquisition of the aircraft. You are protected as a lessee from any bad acts, from any events of default on the part of that lessor that may entitle that lessor's lenders to exercise their rights against the lessor. Now, that's important. We won't go into this in too much more detail, but that's important because as a lessee, or indeed as a lender, you might find in those circumstances that you have a defaulting lessor in the middle, and therefore as a lessee, as an airline, you could find in those circumstances that whilst the lenders to your lessor can exercise certain of their security and can effectively assume the role of lessor, you are entitled to keep operating the aircraft as the lessee under the lease, but you potentially have a situation where your lessor has been, let's say, kicked out by its lenders. So that gives rise to some interesting discussions around what should happen in that step-in scenario. What should happen if the lenders kick out the lessor and are obliged to continue to allow the airline to enjoy that quiet enjoyment? Sorry, Ash.
Okay, moving on to maintenance repair. As Richard said, the lessee will normally assume responsibility for all of the maintenance and repair of the aircraft during the term of the lease. They will also need to action any applicable airworthiness directives that might be issued by the manufacturer or the relevant authorities, and similarly service bulletins. They will need to do so, of course, with an eye on the redelivery conditions that they will need to meet at the end of the lease term. If anything in particular is agreed with the lessor about covering the costs of these tasks, the lease will set this out in an arrangement similar to what Andrew was speaking about earlier. It might be something like the lessee is required to pay supplemental rent every month alongside the basic rent, and that will accrue perhaps in a separate account and then might become available as a lessor maintenance contribution at certain time intervals or certain maintenance events. That's subject to commercial agreement between the parties. Looking more specifically at engines and parts, operationally, it's a lot easier for lessees to pool parts and engines within the fleet that they operate, whether or not all of those aircraft belong to the same lessor. Lessees generally want as much pooling flexibility as possible, and lessors prefer them not to do that. And again, they might be restricted by their financing conditions as to what they can agree in this respect. PMA parts, these are parts that might well be approved by the original manufacturers, but are not actually manufactured by the original manufacturer of the aircraft. So someone like Airbus or Boeing or Embraer, various other manufacturers that you will have heard of. So PMA parts are generally not permitted to be installed on a lease aircraft. And if replacement parts are installed, generally title to those replacement parts will then vest with the owner once they are installed on the airframe or the engine. For engines themselves, the situation is slightly different. The title to the engines will stay vested in the owner or the lessor at all times. And if the lessee is permitted to install those engines on another aircraft, the interest of the owner and any financiers will be recognised by a third-party recognition agreement by the people who will be operating that equipment to acknowledge the leasing and the ownership in place there. Titled engines will be required to be returned with the aircraft at redelivery. That can take a little bit of forward planning by the lessees, because they might need to recover those engines from aircraft that are operating in various jurisdictions. Pooling of parts with other airlines completely is probably not going to be permitted. You might occasionally see that, but that's probably slightly too much flexibility for the lessors and the financiers there. And then if we move on to insurance, when an aircraft is on lease, the lease will generally require the lessee to obtain and maintain comprehensive aviation insurances. There are market standard forms of endorsement that have been developed, such as the Lloyd's ABN 67B form, for example, to provide consistency and certainty as to how any claims will be handled and how the interests of interested parties, the lessors, the financiers, the security trustees, and so on, will be recognised in the event that a claim needs to be made under those insurances. The rest of this slide is fairly self-explanatory. The insurance is there to protect all of those interested parties against loss or damage to an aircraft or engine, and third-party liability claims. That loss can be a total loss where the equipment is a complete write-off. That can be different for airframes and engines. So often a total loss to an aircraft is the airframe plus the engines, but a total loss of an engine can be dealt with separately. The engine may or may not be installed on the aircraft at the time. For example, if a bird strike happens to one engine but not the other, that's what that is intended to deal with. The insurance proceeds agreed between the parties at the leasing stage should be, they're generally going to be 110 to 120% of the book value of the aircraft for the hull insurance, which is sort of the body of the aircraft itself. So that in the event of a total loss, the insurance proceeds will be sufficient to either replace the aircraft or the engine so that can be replaced and the lease can continue, or to repay the outstanding financing that might be in place for that aircraft. And then depending on the events giving rise to the claim, the insurers will pay out the agreed value for a total loss or the cost of repair for a partial loss. So I think I'll hand over to Andrew now to do the transfer section.
Thanks, Ash. So transferability is quite a key issue, I guess, for airlines and lessors. I mean, there is quite a big secondary market out there for lessors to trade aircraft. And so the transfer provisions now therefore be quite a key element of any negotiation. I guess the starting point is that any sort of transfer by the airline itself will almost invariably be prohibited if an airline during the term of the lease no longer has any use for the aircraft. They'll either have to go back to the lessor to try and renegotiate the terms, or they might have subleasing rights if there is sort of sufficient slack in the market to be able to sublease the aircraft. So in terms of a transfer or restructuring from a lessor's perspective, this can sort of be categorized in sort of 4 different ways. There might be the imposition of a head lease where the existing lease would remain in place, the lessor transfers title to a new owner, and a new head lease is therefore interposed. There's also security assignments to financiers, which is, as Richard touched on, is also quite an important issue where the lessor is assigning by way of security its rights under the lease to its financiers as security for its various financial obligations. Perhaps more critical as part of the secondary market is the absolute transfer to a third party. So this is where one lessor is selling the aircraft to another lessor. Under English law, that would therefore require the lease itself to be novated from that one lessor to the other. Under American law, New York law in particular, I think that they tend to use an assignment and assumption agreement, so that's often quite a point of differentiation between the 2 governing laws. And then finally, which is perhaps more of a recent innovation, is either the lessor could create a trust whereby it effectively becomes the beneficiary of that trust, transfers legal title to a bear trustee, which then leases the aircraft back to the airline. Or it could be the case that that trust structure is already implemented and it's a case of then transferring its beneficial interest to a third party. And this is a particular hot topic at the moment because in the past 2 to 3 years, there's been this big push by certainly the bigger lessors to introduce what is called GATS, which is a General Aviation Trading System, which is intended to sort of be a sort of means of facilitating these sort of transfers between lessors without having to sort of touch the underlying terms of the lease and therefore not bother the airline. Although, I mean, in terms of how that is picked up and experienced to date, I don't think it's particularly taken off, especially given that I think the launch of GATS sort of coincided with the crash that resulted from the pandemic. So in terms of sort of key conditions and issues that might sort of arise in sort of transfers generally, an airline's key consideration is it doesn't want to be under any increased obligations or suffer any diminished rights. And this particularly relates to sort of any withholding tax exposure that might arise. And as touched upon earlier, there is that gross-up obligation. So they don't want to be in a position that if lessor A transfers to lessor B, that they could therefore be required to pay any withholding tax that they don't currently do. So, for example, if a lessor in Ireland transferred to a lessor in China and say that there was a withholding tax imposed in China, but there isn't in Ireland, the airline would continue to not have to gross up for any withholding tax that might arise. The sort of caveat there is that there's often a concern around sort of change of law risk. So any lessor would want to be exposed to any subsequent change of law. And so that has to be sort of assessed by the time of the transfer itself. So if there were to be a subsequent change in law in Ireland that did involve a withholding tax, that the airline would still be required to gross up its payments there. Other sort of issues that arise are sort of a quiet enjoyment confirmation from the new lessor or any financier, because there are certain payment obligations that might be incumbent upon the lessor, certainly with the return of any security deposit, or perhaps any contributions from the maintenance reserve pots that have been put aside. The airline may want to have some sort of confirmation that there is a tangible net worth to that lessor, either itself or that it's backed up by a guarantee from a more substantive entity. And then because airlines can often be disinterested in the sort of whole transfer process because it effectively is between 2 unrelated parties, there will often be sort of covenants around cooperating with the process and providing reasonable cooperation in that respect. And increasingly, and it may sort of explain why GATS hasn't taken off, there has been sort of an expectation among certain airlines that they might get some sort of fee for their sort of cooperation with the whole transfer process. So I think that sort of takes me on to sort of the various additional lease documents, which Rohan will cover.
Thanks, Andrew. So as Richard talked about at the beginning, the main lease agreement kind of sits as an umbrella agreement to some of these additional documents which are provided either as some kind of security to the lessor, or alternatively as some kind of, each play some kind of administrative role. So one of those things is a guarantee, and usually the lessor may ask their lessee to provide a guarantee. It can come in a number of different forms. The most common ones we see are corporate guarantees, where a parent company who sits above the lessee in their sort of corporate structure will guarantee the obligations to pay the rent and pay the maintenance reserves and the other aspects that Ashley talked about. The alternative to a corporate guarantee is a personal guarantee. These are obviously seen a little bit less frequently, but there could be a shareholder or an individual who sits at the top of the corporate structure who may have the financial resources to be able to guarantee those financial obligations towards the lessor. The second one is an assignment of insurances, and Ashley talked earlier about the obligation for the lessee to maintain comprehensive insurance policies to guarantee the value, particularly of the hull during the term of the lease. What the lessor will want in that scenario is for a right to be able to go after the insurance proceeds, and the ability to claim those back. And the reason why is because obviously an aircraft generally stores a lot of value in the metal itself and in the engines, and so it may be a route to claim their debt back if the lessor has an assignment of those insurances. Equally in the reinsurances, if those insurances are placed back into the market and reinsured. Very credit-worthy airlines may be able to resist providing that, because with the combination of a guarantee and there are the financial resources and a big security deposit, they may be able to say that they're not obligated to provide that. The next item is a deregistration power of attorney or an IDERA. The purpose of these documents are effectively to facilitate deregistration or export of the aircraft. So usually when you've been in an airport, you may see on the tail markings of an aircraft, there are a combination of a few letters and numbers written at the back. Those codes usually can dictate which jurisdiction the aircraft is registered in. And if there is an event of default, which occurs under the lease, the lessor would like to potentially move that aircraft into another jurisdiction, or potentially export it out of where it's being currently operated. So as Richard says, there are sometimes demands in the market for aircraft to be in certain locations, and in that scenario, the lessor would want a right to be able to deregister or move the aircraft quickly and then lease it to another lessee who's paying and is creditworthy. They're usually recorded with an aviation authority, and there's questions in certain jurisdictions about whether you provide both a deregistration POA and an IDERA, but we won't go too far into detail into that. The next couple of items are sort of more on the administrative side. An air traffic control or an airport's authority letter is basically an information right for the lessor. They can find out if there are any outstanding amounts which are due to either air traffic control agencies or airport authorities. It's not technically a security interest, and it's not registerable, but it's effectively giving the lessor some comfort into the amounts and sums owed. And the next item, again, is very similar. Eurocontrol letter is the exact same principle, but it's for aircraft which are operating within European airspace. The final item is warranty agreements. During the term of the lease, the lessee would want a right to be able to use the warranties over the airframe or over the engines, just in case they need to make a claim if there's any damage during the course of the lease. And there are usually prescribed forms for those warranty assignments or rights to use the warranties, which are either provided by the manufacturer, so Boeing and Airbus, for example, or for the engine manufacturers. And each of those manufacturers have a slightly different form. So Airbus, for example, does their airframe warranties unilaterally. So it's just they're the only party who signs off on the right for the lessee to use that warranty. Whereas Boeing, for example, uses a tripartite agreement, which is signed between them, the lessor, and the lessee. And so all three parties will consent to the right to and the terms on which those warranties can be used.
So turning to enforcement, I mean, this could actually be the subject of its own topic, to be honest, given there's a lot of detail that could be gone into here. So this is just sort of meant to be really an overview, sort of looking at perhaps the sort of contractual framework that really sort of applies here. So as I touched upon earlier, a lease would contain a number of events of default, which would effectively give certain rights if they're triggered. In terms of, sort of the various categories that are covered, they are very much subject to the bargain of the lessor and the lessee at the time. So a top-tier airline will certainly push back on the number of events of default which it has to agree to compared to perhaps a lesser credit. And there will certainly be sort of like a debate as to what extent an airline should take the risk for things outside of its control. So for instance, if there's material adverse change or an illegality event or something along those lines. But these items here are sort of broadly the categories which you'd expect to see at its core in any sort of events of default section. So you're looking at perhaps sort of a non-payment of rent by the airline, a failure to maintain insurances. That's often considered to be quite critical, especially given sort of the potential implications of an uninsured aircraft were to crash. So that can often be what we would call a drop-dead event of default, so it doesn't really have any grace period to it. There will be sort of a general breach or misrepresentation section, which will pick up any sort of general breaches that have been made under the lease with subject to an agreed grace period. The insolvency of the airline will also be quite a key trigger for any event of default, and potentially also cross defaults, which are again themselves very much subject to negotiation, but these may pick up things like a cross default with another lease, which is with that lessor or one of its affiliates. It might look to sort of broader financial thresholds. So if, say, there is the case of the lessee and its aggregate has breached $10 million, $20 million worth of debt overall, that might well trigger an event of default. So in terms of the actions that might follow an event of default, the lessor will have a number of remedies, but one of its sort of issues it will have to weigh up is whether it wants to terminate the lease. And there may be market circumstances where there is a lot of excess capacity in the system, especially when there's been a global pandemic, when a lessor doesn't want to necessarily terminate that lease and wants to potentially keep it in situ. And if that is the case, then it would be advisable to at least serve a reservation of rights letter to the airline to sort of note that there has been an event of default and the lessor is reserving its rights. If it then does come to termination itself, you would look, this is particularly an English law concern, you'd look to the termination of the leasing of the aircraft as opposed to the wholesale lease itself. The rationale behind that is it then preserves indemnities and other obligations which are intended to survive the redelivery and termination of the leasing of the aircraft. The airline itself may be cooperative and may just effectively hand back the keys to the aircraft to the lessor, or there may be a contested repossession, which in itself, as I said earlier, it could be the subject of its own discussion, brings with it its own number of considerations, which will depend on the fact pattern at the time. And there, when sort of repossessing, I suppose the general comment to note is that local factors and the level of administrative cooperation will be very, very important. There is the Cape Town Convention, which I understand you're going to have a talk on later, which is quite integral to aircraft leasing and financing generally. And a lot of sort of lessors and financiers have sort of perhaps taken comfort from ratification of Cape Town in a certain jurisdiction. But as time has gone on, we have seen that that alone is not necessarily a panacea. It is helpful, and it is often a stick perhaps to beat the local authorities with if there are any issues. But if you're dealing with a jurisdiction where the state carrier has gone insolvent or is otherwise not complying with its lease obligations, there could be a lot of sort of soft political pressure to sort of keep that airline protected. So it could, I guess, effectively be more honoured in the breach than in the observance, I guess. And I suppose there have been sort of a number of examples of how Cape Town, where it has been ratified, there have been teething issues over the years. I think we've seen a sort of number of jurisdictions where that's been the case. I think India actually itself was one with the Kingfisher insolvency a number of years ago, where there was some uncertainty around sort of the ratification and recognition of ideas that were registered with the local authority, which sort of stymied the repossession of the aircraft. But I believe that was then actually subsequently resolved. But I would, of course, defer to the Link Legal team on that front. So I think that sort of brings me to the final slide, which is about leasing in a financing context.
Right, good. Well, I want to allow enough time for the interrogation, so I shall do this slide in double fast speed. But suffice to say, what we've tried to do over the course of this hour is really build up the oil painting for you and sort of layer some of the colours onto that picture. And now's really the time to step back and look at what we've been painting. And whether that's with Andrew talking about events of default or the transferability of leases, whether that's Rohan and his discussion around some of those ancillary documents, or Ash talking about insurances or redelivery concerns, really leasing is all about credit risk. And to understand leasing in a finance context, one has to understand where the credit risk is placed, and in particular, the distinction between an operating lease and a finance lease. Now, we could spend another hour or two talking about these sorts of things, but suffice to say that since 2019, a regulation called IFRS 16, but it came into effect from 2019. Essentially, there is no financial distinction drawn between an operating lease and a finance lease anymore. But there is still a legal distinction. And so I'll commend again the very interesting Celestial Aviation trading case. It's very good for getting into this sort of distinction. And fundamentally, the difference between an operating lease and a finance lease is about whether or not the lessor expects at the end of the lease term to take the lease back, to take the aircraft back from the lessee. And if a lessor does not expect to receive the aircraft back, if the lessee is expecting to effectively pay for that aircraft during the lease term, then that is in many ways akin to a financing transaction, and will often be accompanied then by a purchase option for the lessee to take the aircraft, which of course means that for a lessor, they are not worried about the condition that the aircraft comes back to them in. Just one important point to note there is I think the primary jurisdictions for international aircraft finance transactions, leasing transactions, primary international jurisdictions are probably English law and New York law. And there are some limitations in that regard with, we practice in both jurisdictions, so we have no particular axe to grind, but there are some limitations in that regard with New York law where finance leases are at risk of being recharacterized as a secured financing. And that means that if the appropriate security filings haven't been made, what you thought was a finance lease may in fact be recharacterized, particularly in a bankruptcy, as an unsecured financing, and you would therefore rank alongside unsecured creditors. The only other point I will make to allow sufficient time for questions is just around tax leasing. It's an area where we spend a fair amount of our time. Essentially, most leasing transactions will have an SPV, special purpose vehicle lessor. Now, those lessors will sometimes be bankruptcy remote, what we call orphan vehicles, and they may sometimes be subsidiaries of a parent lessor. When you have a tax lease, that SPV will be economically transparent, which means that the investors sitting above or behind that SPV are intended to benefit from all of the economics of the transaction, the aircraft rental income, and potentially ultimately the aircraft sales proceeds, but also importantly, any depreciation that arises because of that aircraft being a capital intensive asset. Any depreciation and associated tax allowances can, in a transparent lessor, therefore be made available to the investors. And those investors can in turn share the economic benefits with the lessee as a way of incentivizing the lessee to contribute to the tax leasing transaction. Comes with certain limitations. Probably the most common that we see in the market are the JOL and the JOLCO, which are Japanese operating leases. The distinction really between those two is just where the residual value risk really sits. That's a requirement of the Japanese tax legislation that the residual value risk sits with the investors, but in the JOLCO structure, there is a predetermined ability for the lessee, for the airline, to acquire the aircraft for a predetermined price. I'm not going to go into any more detail on this at this stage. I think we could probably do a whole another hour on finance, lease finance and transactions. So I will pause there and just thank everyone for your kind attention. We're very honoured by the number of participants, so thank you all for staying with us. And we're very happy to take any questions on any aspect of the presentation or otherwise.
Thank you, Richard, Ashley, Rohan, and Andrew. I mean, for tracing out and drawing this picture and, telling us about each and every nuances which go into an aircraft leasing, transaction. Just a few questions. And first of all, Vanshika, Chandra, thanks you for answering, a question about quiet enjoyment rights, which you picked up earlier on. Mahadev M has asked a question about sale and leaseback of aircraft. He asks what is meant by buy, sell, and leaseback of aircrafts. When and why do airlines adopt this mechanism for procurement of aircrafts? I think, Richard, you are well versed to pick this up.
Yeah, absolutely. Thank you. It's a good question. It's an interesting question. So sale and leasebacks are fundamentally a very, very useful device for an airline where the airline has aircraft on its balance sheet. Those aircraft are capital intensive and it wishes effectively to monetize the aircraft but still have the use of it. So as an airline, you would sell the aircraft to a lessor and you would then lease it back from the lessor. So as an airline, you no longer own the aircraft. You have the purchase price in exchange for it, useful for your accountants in particular. But you then have the ongoing obligation to pay rentals. So it frees up some short-term liquidity and it's a useful device for better managing an airline's capital stack and for better managing an airline's balance sheet, whilst maintaining the use of their obviously fundamental revenue generating asset.
Right. Now, of course, Richard, you also spoke about, complex structures of, net lease and hello high water. You made it sound very simple. Arising from that, one of our attendees, Surbhi Gupta, has asked us what modifications or arrangements were arrived at between lessors and lessees in the existing lease agreements due to impact of the pandemic, and what do you think, in your view, is the path ahead for relationship between lessees and lessors considering the pandemic?
Yeah, very good question, a very topical question, a question that we've spent a lot of time thinking about, so thank you for it. I think that ultimately the hell or high water provisions have been robustly tested by a number of parties, and with varying degrees of success, the hell or high water concept has been found to be sacrosanct. So essentially the risk of, and this is to my earlier point about credit risk as well, essentially the risk of that asset is with the lessee under an operating lease. And that means that quite literally come hell or high water, come COVID-19 or otherwise, the responsibility for the aircraft and for continuing to pay rentals in respect to the aircraft remain in almost all respects with the lessee. Now, that's not to say that lessors haven't become nervous and sort of keenly tuned in to some of the arguments that have been made by and on behalf of airlines. And so we are seeing hell or high water clauses that expressly reference pandemics as a way of making it clear that it really is an absolute provision. It really is sacrosanct in the sense that there is nothing out there that we can imagine that could ever possibly befall any of the global aviation community that would cause a lessee to be able to sidestep its obligations under the lease. So you are seeing some fine tuning. There hasn't been much legal process in terms of circumnavigating the hell or high water provision. But I suspect that there are remaining good arguments on the part of airlines around the circumstances in which it is just and equitable to be able to force an airline to keep paying for aircraft. But certainly under English law and New York law, the prevailing view has been that the leases in their current form work, and the lessors are just fine tuning.
Yeah. I'll just pass on another question. Vanchika asks, can you please explain how termination of leasing differs from termination of a lease under English law in order to preserve indemnity?
Yes, I will let Mr. Harper take that question, seeing as it was on his slide. It's a favourite of all of ours. But Andrew, why don't you field that one?
Yeah, I mean, I appreciate it. It's a particular nuance to it, but the idea is that you have the lease framework. It has certain contractual obligations which are set out within it, and there are obligations such as indemnities. They will often be expressed to survive generally. So when it comes to termination and wanting to take the aircraft back, it is advisable to say that you are terminating the leasing of the aircraft, thereby effectively terminating the right of the lessee to continue leasing it. But in so doing, you are sort of preserving all of those obligations, such as the indemnities, so that they continue to survive. I know that I think New York law can differ slightly. They can sometimes refer to sort of the termination of the lease. I think that's a sort of particular element of New York law, and I think they perhaps take the view that all those various obligations continue to survive in any event. I mean, that's a sort of like an example of sort of how American and US and British practice can differ.
Right. Thanks, Andrew. Thanks for picking it up. Actually, I think you spoke about delivery, redelivery, and repossession of an aircraft. There's a very interesting question asked by Prakriti. She says, are there any restrictions on the ability of a lessor to export the aircraft from the operator's jurisdiction on termination of leasing? Then she asks, what jurisdiction would you say, in your view, is the most suitable for aircraft repossession within developing economies?
Well, if we're talking about at the end of the lease, I think you mentioned that the question was what would happen once the lease is terminated. So once either the lease or the leasing of the aircraft is terminated, then the lessor is free to deal with that aircraft as they see fit, according to the next arrangements that they have in mind for the aircraft. It might need to be moved to another operator, and to do that, they might need to move it to another jurisdiction. So once all that's terminated, then they can deal with that as they like. In terms of enforcement, that's a hugely complicated.
Yes.
Just before we get on to enforcement, just to mention as well, in the lease, the return conditions will usually stipulate for example, redelivery to an FAA or EASA approved facility in location X. Now, location X may be rather wide. It may be anywhere in Southeast Asia, for example, but it will specify the type of facility to which the aircraft must be returned. And so the lessor therefore has control that the lessee will bring the aircraft, assuming it doesn't default, will bring the aircraft to a facility from which the lessor can then export it. Now, if you have a consensual export, it's really quite simple because the outgoing airline, for want of a better description, will apply for what we call an export certificate of airworthiness, and we'll give that to the lessor, and the lessor can take the aircraft wherever it needs to go, put it into the shop, put it in for painting, put it into the new livery, and deliver it to a new airline. Obviously, in a non-consensual termination of a lease, then in those circumstances, you're looking to the devices that Rohan was talking about, the IDERAs and the deregistration powers of attorney. But I think Ash was about to come on to enforcement, and that's fraught with all sorts of then practical issues around how you actually extract an aircraft from a jurisdiction without the cooperation of the person in possession. And I'll let Ash talk to any points she wants to make on enforcement, but just to the specific question, which is the best jurisdiction to repossess in? There are many jurisdictions in which we've successfully repossessed aircraft, and I don't think that necessarily there is one jurisdiction that is the best. But you're typically looking at a couple of factors. First of all is, has the rule of law generally a country, has it been robustly tested? Has aircraft or asset repossession been robustly tested and respected before the courts there previously? What is the status of the Cape Town Convention there? And is it respected in both legal and practical terms by the authorities? Ash can talk about some experiences we've had in South Africa, where they've very much paid lip service to it. I think the third factor is purely practical, because if you are seeking to repossess an aircraft, you need appropriate local experience, legal, technical, you need pilots, you need to be able to get the pilots in to remove the aircraft. So there are a myriad different factors, and I don't think that I would want to say that one jurisdiction is necessarily better than the other. We have extracted aircraft from many challenging jurisdictions, including Eastern European jurisdictions, where some of the let's say some of the rule of law questions around the respect of creditors' rights were perhaps still unanswered, and really it's a question of where is the aircraft at the point in time that the repossession action is to take place. Ash, do you want to just mention the idea of point?
Yeah, sure. So as Richard said, it is totally fact dependent on the circumstances at the time. But we have had a situation where in South Africa where Cape Town has been ratified, and officially the government agencies need to comply with their Cape Town Convention obligations. In practice, the airline that we were dealing with was not cooperative, and they were very influential with the local aviation authority, and were going to make it very difficult for the aviation authority to actually honour the idea that the lessor was going to rely on. So even where there looks on paper like there's going to be a clear legal answer to the question, in practice it might very much depend on the political influence of the airline, or the political will of the aviation authority, or even something like the contacts in the courts of the local council team that you're using.
Yeah, exactly. So the aviation authority said, yes, we respect your idea. We're very, very pleased to be a Cape Town contracting state. We respect your idea and we will honour it. We need to get 17 or 18 signatories, of which 9 of them are currently laid up with COVID. So, get back to us next Christmas. So it doesn't necessarily matter what the legal regime is if those sorts of dark arts are being deployed. And we see a lot of that around enforcement scenarios.
Right. Thank you, Ashley. I mean, thank you, Richard, Andrew, again, for picking this up, for picking these questions. I hope it was not a detailed interrogation that you were looking forward to.
I was disappointed, Kashish. I was very disappointed. I was looking forward to really being made to sweat, but I'll save that for my next trip to India.
Right.
Thank you, Richard. I think the questions are so many that we could do a completely different session for this. There are like 40 questions waiting for you, and we have barely answered, I think, 3 or 4.
Well, thank you. Hopefully that was because people were interested and not because we were failing to do justice to the topic. But
no, not at all. I'm sure they are very, very interested and keen listeners. I'm quite glad, like you said, the numbers look really good, and I think everybody has learned a lot today. And like, yes. Thank you so much. Thank you, everyone, for this. It has been incredible. Thanks.
Thank you for your kind words. We're happy to continue the discussion offline with anyone who wants to follow up with us. I think we're all quite easy to find on the website and on LinkedIn. So thank you all. Thanks for allowing us to participate, and good luck with the rest of the program.
Thanks, Richard. Thank you.
Thanks very much.
Thanks very much.
Bye-bye.
Right. Moving on. Now we will bring on our next set of speakers. Our next session is about aircraft acquisition, and we have our senior equity partner, Mr. Anand Srivastava, and who is assisted by his team and our co-partner within the firm, Ms. Namita Das. Anand is an equity partner at Link Legal. He has 2 decades of experience behind him. He is dual qualified and admitted to practice in both India and New York. Anand completed his LLM from Columbia Law School, where he was selected as a Howland Fish Stone Scholar and awarded the Edwin Parker Certificate for International Law. He is also qualified as a trained mediator with the New York Peace Institute and has worked extensively at the mediation clinic at Columbia Law School, where he conducted several workshops on conflict resolution and mediation for United Nations Institute for Training and Research, and at several other US private and public bodies. Anand completed his LLB from University of Delhi Campus Law Center. He's also a member of the Institute of Company Secretaries of India. He is a trusted advisor to his clients, highly recommended by various global directories. He's recognized as a leading individual. He features as an elite A-list lawyer. He is, to add he's a go-getter. He brings in a fresh perspective every time he gets on with clients. He adopts a novel, out-of-the-box hand approach with his clients, and he's widely recognized amongst all peers. Namita is equally strong and experienced. She has more than 11 years of experience, and she is an expert, just like Anand, in aviation law. Welcoming both you and Namita, sir. Handing over to you, please.
Thanks, Kashish. Somehow our video is not able to be turned on.
Yeah, it says the host has turned it on.
We start, Kashish, do you want us to start without the video?
Anand, hi, this is Namita. So we are, sorting it out with the IT. The host, I think there's some glitch in the host has not switched on the video option apparently. So it's just getting fixed.
Yeah, so it will just take a minute. Just bear with us for a minute, and we can start.
I think we can give the listeners and the audience a little bit of break as well.
Sure, sir. Sure.
The videos should now be available.
Thanks, Farah. Cool. Oops. Great. So thank you, Kashish, for the, if I may say, over-the-top introduction. So I think before we kind of deep dive into aircraft purchase and the objectives of this session, I am conscious of time. We are, I think, 20 minutes behind schedule. So what we'll try and do is mostly, maybe address the high points of aircraft purchase. Also make this relevant from the perspective of the audience. I understand we are addressing the students and also trying to ignite the interest of aviation law in students. And therefore, why aircraft purchase is an important topic. Why should aviation law be of interest to students particularly? As you know, India, maybe we can go to the next slide, Namita. So we will touch upon a few topics. Of course, I will give you an industry overview. And Namita will then maybe introduce the session, providing a snapshot of the aircraft purchase, and we'll of course quickly go through the formal steps of aircraft purchase, where you will understand the importance of airplane configuration. What is the build process like? Because as you know, an aircraft and a ship both take more than a year to build. And there are more than 1 million parts that come together to make an aircraft. It's one of the most sophisticated machinery that is available and has been flying for the last now so many years. And then we will see what is the delivery process like, what goes into a delivery process. Towards the end, we will save the legalese for the end, where we will go through the purchase documentation and give you certain high points, at least, from a legal perspective that are important and of course, very, very material when we do any aircraft purchase transaction. So next slide, Namita. So from an industry overview, just to tell you, India is the 3rd largest aviation market in the world today. We are the 3rd largest also aircraft purchasing market, only behind United States and China. And if we read our economic survey, which is published annually, anyone of law students as well as lawyers who want to practice corporate and commercial law should read the economic survey, because it sets out what the India and the Indian government are doing in the coming years. And the economic survey speaks about a price parity between railways and airlines. And what is expected already, for example, if you were to purchase an executive class ticket by, in a Shatabdi train from Delhi to Amritsar, the price is about 1,800 rupees, sorry. And if you were to buy a lowest fare between Delhi and Amritsar, it's about 2,200 rupees. So what is expected in the coming couple of years? Of course, COVID was a big dampener. But what is expected is in the next or next to next year, there will be a price parity between the two media of travel. And what will happen is we will see at least one person from every family moving on from railways to air as a medium of transport. Now that will result in a 6 times growth in the Indian market for passenger traffic, as well as create a huge opportunity for aviation and aviation lawyers in the country. Presently, next slide, Namita. Presently, for example, the nearest comparison of population is China. India has only 700 aircraft, or 700 thereabouts. We are at 622 today. China at the same point of time has 6,100 aircraft. So you can imagine the volume gap that we have and the opportunity that us lawyers have to play in this sector. Also, you will see that the demand of passengers in India is far lower. And this is what we are talking about, 6 times growth in the coming next 15 to 16 years. And therefore, what we expect is a huge order book of aircraft. India already, as I told you, has a potential aircraft growth of more than 6,000 aircraft in the coming years. And coupled with that, what we see is that the next 20 years also sees a great focus on technology, already industry experts speak that the last 20 years, if you were to take 2000 to 2050 as 50 years of change, the period between 2000 to 2020 has been the slowest pace of change that we are going to see from 2000 to 2050. So what we are going to see in the coming 30 years is a great focus on technology, on fuel efficiency. Namita will talk about the new types of aircraft and how they are more fuel efficient. And obviously that brings along with it cost efficiency. By 2040, we also expect that the latest generation would constitute a majority of the fleet. And therefore, our Prime Minister has already committed that by 2050, India will be carbon neutral. So therefore, a younger fleet will be more efficient and more cost effective. Next slide, Namita. Over to you. Yeah.
Thanks, Anand. That was very helpful. Thanks, Kashish, and all the panelists who spoke earlier. So on this, like Anand has given an introduction that where is the industry going? So like we discussed that the Indian aviation industry is obviously going to see a lot of growth. So now to tie into that growth, there has to be, we are talking about aircrafts in this session. So there has to be enough aircraft within the country with all the airlines to meet the requirement. That is the obvious next step. So which is why we are talking about what is a fleet size. Now, why? So the fleet size has to increase in the country so that we have enough and more assets to cater to the increasing demand. Now, how does one manage the fleet size? Because suddenly demand is raising. We are all talking about it. We won't have aircraft sitting here within that time. So the planning starts with all the aviation players right now, whether they are the manufacturers who will get the demand and start manufacturing. But there are two things to that. One is obviously what is the industry demand, like Anand mentioned. The other one is an operational demand. Here is where we are talking about there are different shapes and sizes and prices of the aircraft. So you have to plan according to your operation of that particular airline. Then there's fuel efficiency. Now, why is fuel efficiency important? This is a factor. I mean, it's a aviation fun fact. I don't know how many, non-aviation lawyers or people just on that front. Is because, for example, whenever a airline starts their first flight, they take into consideration the duration. So what would be the fuel efficiency? And the fuel efficiency is also dependent on aircraft to aircraft, further on including things like where do you park your cargo, for example, whether on the belly of the, towards the belly or up. So therefore, there's a lot of variable which needs to be considered while one plans the fleet, which is of course tying up to the demand. Gauri, next slide, please. Thank you. So now how does, we already touched upon on why do we need to, plan our fleet so that it's cost efficient and demand. And now what are the factors do we consider when we do the fleet planning? So of course, the first one is the cost of the aircraft and type cost, because with every upgrade, there is a price implication. Ultimately the financing, which Richard spoke about, is the key of how the business functions. Then what are the maintenance intervals of these aircraft, and how will the pilots and the flight attendants be able to operate? For example, here I would just stop here and example, if we look at the Boeing Max, which got grounded. So what was the issue there? The issue was of software. While it's disputed all over, but it was also on how the pilots are operating and all the software. The whole dispute was how that was being done. So therefore, when new assets are being ordered, in factors including this, whether your human resource, which is your pilot and your flight attendants, how can they operate it, or how efficient it is. Then what if a new aircraft is not proven and there is much data on maintenance? For example, this is where Max would also come in, that it was operated, but the operation wasn't used. So therefore, which aircraft are you inducting into your fleet is very important. Whether it's a used aircraft, new aircraft, those are also consideration. And of course, then there are the usual, parameters of how are the passenger experiences relate to, and how does the aircraft type vary and fit into the airline network. Because, for example, here a point is that some airlines, when they start with a narrow body aircraft. Now, whether those narrow bodied aircraft are good for, say, a small duration. Now, this airline starts flying long duration. So that aircraft might not be suitable to fly that duration. So therefore you need to, whether you have a mixed fleet or you have one type of fleet, depends on a lot of factors which we just talked about. Gauri, next.
Thanks.
Over to you, Anand.
Thank you. So also there are several types of aircraft which are presently, available for purchase. Of course, we have seen recently military aircraft, the deal that we did with France, Concords, which are now, rare, commuter lines, regional short haul, feeder line aircraft, narrow body and wide body. Wide body is what we normally see as the A380s, etc. And of course, passenger aircrafts and jets and jumbo jets. So the complexities of a purchase transaction may differ on the basis of the nature of an aircraft. Such as, let us say Dreamliner was introduced by Boeing and Air India became the first customer. But what we saw with Dreamliner was that, there was a faulty door issue. And of course, a lot of media and inquiries were made into how the government acquired Dreamliners, etc. So I think all of these issues are dependent on the type of aircraft that is purchased. And as Namita was saying, the issues around new aircraft and old aircraft are always complex, and they are subject to, several moving pieces that are, to be considered at the time of an aircraft purchase.
Anand, I have a short point to add on that one. So just as a trivia of the sector, like Anand mentioned, that of the Dreamliner, here also like Concorde, which were very, interestingly, they used to, they were supposed to reduce the journey from New York to, Tokyo for 6 hours, I think. But the implication of these kind of, now again, the fleet management, we can bring in here also. For example, there's a company called Boom, because Concords were removed because of the price implication, the ozone layer implication, and also the fuel implication. So however, with the whole travel and COVID coming into play, there is a company called Boom who is coming out and has tied up with the United Airlines of the US. Again, they're assuring Concorde level of speed. Of course, price would be an implication. However, before implementing that, now we are all talking about sustainability and environment and so on and so forth. So again, we are yet to test on how Boom, will it see the same fate as a Concorde, or how will the fleet, will there also be a viable option of travel considering the price implication and the environment is something that, just to add on to what Anand mentioned. Thank you.
Yeah. Right. And the players in the Indian aviation sector are, of course, the manufacturers, the operators, and the end-use consumers. Manufacturers, as you know, are Bombardier, Airbus, and Boeing. Boeing is a US company, Airbus is French, and Bombardier is Canadian. In India, we, of course, have a lot of airlines presently who are called operators. And they operate under an aircraft operating license, which I think Mr. Sharma covered yesterday. And these are Indigo, Air India, SpiceJet, Vistara, Akasa, Go Air. And of course, end-use consumers are consumers like us. Next slide. Gauri, thank you. Right. So, Namita, do you want to take this slide?
Sure.
Yeah.
Yeah. So now we, to start on the manufacturing, or rather the building. So what we were talking until now is that how is the demand moving? Are we ready? What do we need? And of course, the point is on aircraft, so that we need more assets to cater to the demand. Now, coming on the topic in itself, that why is the building bit so critical? So here is, if you look at, we began this session by saying that the asset here is a multi-million-dollar asset. It involves an OEM, it involves various parts, and it involves suppliers. So it's a multi-jurisdictional point, and also a lot of components are involved. If you look at the slide here, why the reason we have put it here is, all of this will be talking subsequently, but if you see, the first picture is of an airframe. So an airframe is the main frame which is manufactured by, say, a Boeing or an Airbus. Suppose that there'll be wings, there's something called a buyer furnished equipment. Those are at the option of the buyer. For example, what seats do you want to use, because the weight of the seats also have an implication on the efficiency of the flight. Then of course, then there's a whole assembly process. So what we are trying to say is there's an airframe, there are parts which come, then the assembly happens. And this process is where the contracts and the commercials come into the place. So this is where we will be tying in with all the concepts subsequently. Gauri, if you can change that. Yeah. So now we spoke about all the parts, how tedious it is. Now on the, I also mentioned that this is a cross-jurisdictional process. So what we are trying to explain in this slide is, if you look, this is a Boeing example for now, we are taking that. So the first picture that you see is how Boeing manufactures. So Boeing's main delivery and assembly facility is at Seattle, Renton. However, because the parts are so big, they say, for example, the frame comes from Utah. They come, and we, in fact, Anand and I had the good fortune of visiting that facility thanks to our, client. But for example, from Utah, it was explained to us by the Boeing facility people that the airframe, which is a green color, frame, it comes on a train, and the frame is parked for a bit. Then there's an assembly line where the frame will be put in, and then all the parts start coming onto the frame. So that's how your aircraft manufacturing happens. Now, the complicated bit here, what I just spoke about in the previous slide, is it is not just Boeing products which are getting, or rather OEM, a manufacturer's product which is getting fit in. There are suppliers, the customer will choose some, there will be some designated suppliers. So there are a lot of people who come, and the assembly happens at Renton, Seattle. Now, once the aircraft is there, there are various processes which we will talk subsequently. Then, like Richard mentioned, then we travel to the lessor jurisdiction, and from there, the aircraft comes to India. Now, the point is, obviously, I'm sure we spoke about in the previous session on how the ownership is different. Aircrafts are bought on a leasing basis as an operator. So this is a picture of a typical operating lease that we are talking about, how the aircraft flies through. So now, how is this relevant to the current topic? Is because all of the contracts perspective, the legal considerations that happen vis-a-vis the OEM, whether it's Boeing or Airbus, will happen at the first picture level. That is where it's important. Second, when we reach the Ireland map, that is where the leasing will happen. And India, of course, the customer is sitting here. So every contract has an implication from India. So this is the overview of the why are these contracts as complicated as they are. Gauri, if we can move to the next slide. Sure. So now the next part is on build to purchase. This is how the process overall looks like. So of course, like when we buy any asset, there are the good news or bad news in this sector is that there are only three, or rather two main OEMs here, whether it's Boeing or Airbus. So you obviously discuss with them. There's a price implication. What kind of flight do you want to use? So everything adds up to these discussions. And that's when the next step is, that's how when you choose the OEM. Once you have chosen the OEM, and how you will also choose the OEM comes to the second point, which is your aircraft configuration. Now, even when we buy a speaker or even a car, we look at the specs. So this is where the specs come in, which is the configuration of the aircraft. And this ties into everything that we talked about. Whether the avionics configuration, software configuration, what your aircraft finally is capable of doing is where is the configuration that is being offered by the relevant OEM, and what do you choose from those configurations. Now, once you have chosen those configurations, then comes your implementation, which is the aircraft build process. So once it is implemented is once it's assembled, and then the delivery process happens. Now, the fifth box that you see here is on the documentation and warranties, because like we already spoke about the interface of various stakeholders here, the documentation becomes very relevant from the OEM's perspective and from the buyer's perspective, because what are my obligation? The OEM will say that I'm giving you this is my product. that you are getting from another supplier, so that is there. So this whole process is what the topic is today, that how is this addressed and what are the key points vis-a-vis the documentation. Gauri, next slide, please. Now, as a carry forward of the previous slide, this slide talks about how, what is the back-end activities and how does this tie up to the broader life cycle that we talked about in the previous slide. First is sales and marketing. Now, this is where the customer will go and meet the sales guys of the OEM. They at this stage, and then comes the engineering and manufacturing once you're okay with all of that, and then the post-delivery. Now, between each of these steps, like I said, sales and marketing happens between the customer and the OEM. At this stage, the proposal is accepted. The definitive agreements are negotiated, the purchase contracts. The configuration, like I said, is zeroed in. The suppliers are selected, and also what are the certificate? Now, this asset needs certificate to whether fly or, to fly out of, say, America and to even fly in India. So there are various roadmaps for what certification are we going for, and whether, and it's a negotiated term. So whether is, say, for example, if Boeing or say Airbus is making their an aircraft that any airline in India is buying, they will give you their EASA certification. Now it's a negotiation tactic whether you can convince them and show them value that, look, without an DGCA, which is my Indian regulator, without that certification, it's pointless for me to get the aircraft from France to India. So now that is where the negotiation part comes in also. There are various market precedents on that. It's no standard rule on this one. Yeah. Then comes the engineering and, sorry.
A good example, for example, is that India and the United States are the only two countries that have satellite navigation as an important element of civil aviation. So while, let us say if you are flying in a CIS country or, even a United Kingdom or Africa or, any other place, satellite navigation is optional. So, so in that sense, India and the regulators' requirement is very, very important. Go ahead now. Yeah, Namita.
Thanks. Thank you, Anand. So in the next point, which is engineering and manufacturing. So once you have agreed on all of that, now comes your implementation, what we already talked about, the technical coordination meetings, because like I said here, all the galleys, all of the labs that we see on an aircraft, everything is selected and your technical teams coordinate. These is entirely an engineering process. Then your final foreign certification plan happens. This is when what Anand just said will finally be agreed at this stage. Then your rollout and your delivery. Now, what do we mean by rollout and what do we mean by delivery? Now, rollout is when, because Anand can correct me if I'm wrong, but what we saw at the Boeing facility was that you enter and there's a line where the frame goes and one step at each part gets, keeps getting added. So at the end, the aircraft is rolled out. Now, once it is rolled out, is it ready for delivery? No, because, it could be, but there are processes within the documentation to fulfill. The customer, the OEM will inspect it itself. They will have some ground tests, which we will talk about. Then the customer will inspect it itself. And if all is kosher, that's when the delivery happens. And delivery has a lot of processes, which we will also talk about. And finally, of course, the post-delivery support that happens, whether it's a credit worthiness certificate and all of that. So that is how we are on this stage. Go to next. Yeah. So the next part is on aircraft configuration. So here we will talk in detail as how the configuration cycle happens. It is more or less on what we spoke earlier. So I'll quickly brush through those. The first one is obviously the proposal acceptance. So when I speak about the proposal acceptance, key point here, the proposal is like, to put in very simple terms, the proposal is like a term sheet and the definitive agreement comes in when you finally have visibility on what your commercials and how are you agreeing, and who are your lessors, you're factoring in everything. So that's how both the steps are put. But proposal is not a mandatory thing, because in a recent deal, we did not sign a proposal, whereas in other deals you do. That's like a term, binding, non-binding, however. But between these two stages, the important points on the config discussions happen. The customer, they can tell you that these are the configurations we provide. You do have the flexibility depending on your commercials, that they will just say, oh, you want this configuration, give it to us, we'll give it to you for extra money. But point is, whether you want to go for those commercials is where the commercial angle of the deals also come in. Fact to be noted here is the asset in this kind of a transaction is so huge that it is not just a law, a unified law that is governing this contract, but it is also the way these deals are structured. As in, what are the typical configurations provided? If there's an extra configuration, how much amount is given? So there's flexibility, commercial flexibility to the parties also. Then we come on implementation. Of course, here is what we spoke about, that the configs get implemented, assembled, then rollout and delivery, final test and flight test is where it happens. Next slide, please. Yeah. Now, as you know, what we have established so far vis-a-vis the aircraft is that configs, your specs specify what your aircraft cannot do and what aircraft is it. Now, once you have zeroed in on a config, do you even have the flexibility to change? Answer to that is yes, because ultimately the end user decide what he wants and what he doesn't. But there's a method to how this is done. Is if you want to do it between the initial and the final configuration, you can obviously, you have record option. There's a mechanism on what you will agree with your OEM. Once you have signed the document, now at the implementation, if you want to change the configuration, now that process is, there are two ways of doing it. Either you agreed upfront in your contract, or what we recently heard with an OEM is that they say that we discuss and finalize these things, and that's how it's an evolving process. So there's either you can document it, or it could be a commercial discussion. That's there. Now, after that, once post-delivery happens, now if you want to change them, then even for that point, there is a specific provision in your contract, which is called a retrofit provision, which comes in a maintenance contract, etc. How you can upgrade or change a few points of your few configs of your aircraft. So as you see, the point that we are trying to make here is, taking from the last point, is that these contracts do have commercial flexibility, and the logic is simple because the airline is using it. So it is the airline who can decide what they want, but it also depends whether your manufacturer can offer it to you. They will always offer everything for extra money, but then again, we have to meet at the middle ground and see how these aircrafts meet our requirement. And for that, we have the configuration changes, which we just spoke about. Next slide, please. Yeah. So now this is the stage one, as we call it. Now we will be talking about how the aircraft configuration happens. Now, while we have touched this upon, an aircraft comprises either of an OEM product or supplier product. Now, the distinction here is, from a legal perspective, it is important because who is standing behind these products? Whether it is the OEM warranty, for the legal concept here that is relevant is who's warranting these products. Say, for example, if you're buying from Boeing, is Boeing warranting everything just because they're assembling it? So all of that aspects we'll be dealing with when we talk about the documentation. But for now, the distinction which we have to remember throughout this discussion is that one is the Boeing product, which they manufacture according to their standard, which is the OEM product, could be an Airbus product, whatever. Then there are supplier products, because these are where it is the supplier, the customer coming in front, they have the, the flexibility to choose who are the supplier, what kind of seats they want. So for all of that is a separate bucket. So these buckets are important because this is where our legal obligation of the OEM comes in, and our rights on who is standing behind the quality assurance of my products comes in here. So yeah, so once you have, like we said, that once you have decided on your configuration, then comes your build process. So we will be now giving a snapshot on how the building happens. So simply to start with, and what does an OEM do? It assembles, it manufactures. If it is an OEM product, it will manufacture. If it is ultimately at the assembly line, they will assemble all of it and give you the aircraft. So here, if you look at the first bit on manufacturer, we have made that distinction. But what happens after that is they give you the customer quality support, which is sales. They have multiple teams: their sales team, their warranty team, their customer engineering team. Because these are not layman things. There are manuals after manuals which you will have to read, and how they assemble all of this. So these are the specifics that they keep in mind, because they will have a spec and their engineers will keep ticking it, and that's how the assembly also happens. Then comes the customer review process also. Now that the customer has the right to inspect, the customer representative can be at the OEM facility. It all depends whether you have what kind of whether you want to do it over the phone, or whether you want your people to visit there once or stay there for 6 months. We have seen precedents for both. Then here comes a customer review location. So where do you, depending on where it is being manufactured. For example, in Boeing, what happens is there is an assembly for your commercial aircraft at Renton, Seattle. But then there is Everett facility, which is the biggest aircraft manufacturing and assembly facility, where there are those other kind of aircrafts. And if it is a defense aircraft, where is it coming from? So these are the different locations which you have to agree upfront. Because these are and it's not as simple as buying even something as big as a house, because here your parts are something that you will have to live with. And one, I would quote Anand here on our negotiation, is that he said that the OEM and the airline are, one is as good or as bad as the OEM is. So therefore, your products, wherever they are, you have to, this is where your their bill process comes in, what quality assurances they are using, what location they are giving. Everything has a cost implication. Therefore, all of these concepts are pegged to the the documentation, and that's where the customer has to clearly evaluate what is it that he's looking for, how much money is going in them, what is the ultimate implication on the pricing, so on, and also the delivery schedule. Yes, the bill process is very important, because this will determine, like we said in the beginning, an airline takes approximately 12 months to be manufactured. So therefore, with that, everything that you are doing, your inspection, your pricing, everything ties up to the delivery schedule ultimately. If you could please move on.
Also, just one more point. When we order a fleet, let us say we order 10 aircraft. 10 aircraft would be delivered over a duration of time. Sometimes, because the manufacturer only has this much capacity. So let us say Boeing could manufacture 500 aircraft in a year for the whole world, and of one type, let us say. So those also have to be, there are slots which are there, which have to be purchased. And therefore, the delivery schedule is something that Namita, of course, spoke about. So when you acquire a fleet, it's not as if you buy 10 aircraft and you'll get all the 10 on the same day or within a month of each other. You could have them, spread over a period of 3 to 7 years as well. Go ahead, Namita.
Right. Just a small point, Anand will add. One of the anecdotes from our meetings with Boeing is that they said, for example, we told them that what if, because of how it happens is in the assembly line, assuming Vistara buys from Boeing and assuming Akasa is buying from Boeing, Vistara aircraft could be before Akasa, and if there's a delay in Vistara aircraft, there could also be a subsequent delay in Akasa aircraft, because they're all on the same assembly line. So what they were trying to say is that it is not practically possible to lift one aircraft, say the Vistara aircraft, and put Akasa in front, or do the reverse. So this delivery schedule, that's why it is tied up to the documentation so tightly, because when do you start your operation is also contingent on how their assembly line is going, which is Anand was just mentioning.
Yeah. And so there are early warning systems that are put into the contract, that if there are any delays, then both parties have to be notified. The schedules are moving. So it's a very, very, if I may say, bilateral process and not a unilateral process with the original equipment manufacturer or the OEM, in this case being Boeing, or in case not Boeing, Airbus. So.
Yeah. Sure. So the next point and the third stage is the delivery process. So here is where everything will come and tie in on what we were talking about. So now let's look at it that the rollout has happened. Everything has been okay, and your aircraft is out of the assembly line and is ready. Now, like we mentioned earlier, it could or couldn't or may not be worthy of delivery, or rather to your specs. So what happens first is there's a pre-flight testing, which is done. So yeah, sorry, before I start, this delivery process has obligations of the OEM, could be Airbus or Boeing, and of the customer, because first they will do their test, then they'll give it to you, then you will come and do your test. Now, if you find any defect there, now that defect correction is the mechanism that you will finally agree in your documentation. So that's how everything ties up, commercial aspect with the legal aspect. So first, the pre-flight, and the pre-flight is the first ground functioning test flight, which is done by the manufacturer. Here they would test, for example, from all the, say, they don't test avionics engine, which is done at the production flight, but here they test your regular stuff like braking, your landing gears, etc. And how they are, they're taxing in their facility itself, because they have those test grounds. Now come your production flight. These are the other functional tests. Here comes how much fuel efficiency is the fuel efficiency is the aircraft doing, how much load are they taking, so on and so forth. How are your softwares functioning, because their softwares are very important part of your how your aircraft operates. So these are the 2 points where it is done. Now, once any OEM does these 2 sets, then the customer introduction meeting happens and the customer walk happens here. Now, these are obviously, so what happens is that the engineering teams of both the parties, they meet, they open the specs that they agreed, they will walk around, first they will walk around the aircraft and see the interiors and exteriors. If all the physical points are okay vis-a-vis the specs, then also comes your software, etc. So in legal terms, for us as lawyers, what is important is that say if we are representing an airline, your airline is getting the opportunity to go and inspect the product before it is being delivered. So this, if you tie in with the contract law, comes your concept of buyer beware. You may know that something is wrong, or rather you got the opportunity to figure out whether something was wrong or not. Now, whether that dilutes your liability, or rather your ability to ask for a claim later, is something that I think, Anand, you wanted to quote an example here.
Yeah, so I think one example that we have seen, of course, was in the case of a Romanian airline taking an aircraft on lease, where what had happened was that the customer did inspect the aircraft, and after the aircraft was inspected, it was taken on lease and it was flown. But then, the hull had problems, the main airframe, with the paint. And as a result of the paint coming off, the aircraft was obviously, it had a crack underneath the paint, and that could not be seen by the plain eye. The court went on to hold that, that it could be said that this was the customer's fault, and also brought in the concept of the intended purpose, that, who had the expertise of producing the aircraft, whereas, the operator or the airline had the ability to only operate it, and they were not supposed to be, So there are, of course, case law on both sides. This is a very, very sensitive topic when it comes to a customer walk. We have had airlines such as, Indigo, which says that it doesn't want to do the customer walk and asks for delivery of the aircraft in India straight away, and asks, the seller or the OEM to include that price as a service addition in their price. Whereas there are, of course, other customers such as SpiceJet, which does do an inspection at the Boeing facility and get satisfied about the quality of the asset. So I think both those examples are there. And there are, of course, risks on both the sides associated with it, as well as costs. Gauri, maybe you can move to the next slide. Thank you.
Anand, would you like me to take this up?
Yeah, please do. No.
And I have got a reminder, and I know, Kashif, that we are running short of time. I'll try as quickly as possible. So here, what we have said so far is tying up here, that the customer demonstration flight happens. It's not just they go and walk, now that pilot could be either mine, that is the customers, or the OEMs, depending on your cost thing, whether you are willing to get your pilot to fly from here to Seattle to test it, or you trust Boeing's pilot, that's up to you. So here, a pilot that you've agreed on will fly your aircraft and see if all the specs are okay, if landing, taking off is fine. Then your document review happens, because here, before the delivery process starts, you agree on an agenda. There are 120 things to be ticked off, because there's also an assignment to the lessor which will happen. You will have to sign off on the spec, because once you sign that this asset is as per my specs, that's when your, the buyer beware is done. So that is how, sorry, Anand, you were saying something.
I was just saying, like, to give you a sense of how many documents are involved, it's about 3 feet of paper per aircraft. So
apparently it has been digitized now, because they did so the fun fact here for everybody is, during the COVID, apparently one of the airline manufacturers got their aircraft done on time. They did a Zoom delivery. I think that was told to us. So that was the delivery can happen anyhow now, apparently. So then the certificate process is super important, because without your certification, the flying out of that jurisdiction and coming to your jurisdiction is obviously an issue. Then there's delivery and customer flyaway, where transfer of ownership happens. And then, of course, here there are 2-3 important, like what I'm trying to achieve here is that things as simple as that when your aircraft flies from Seattle to Ireland, assuming, so who fills in how much fuel on that, and how many refueling will happen, how many pilots will be there, whose pilot are there. Those are also processes which are discussed and documented. Coming back and reiterating the same point, that these contracts are legal and commercial. It's up to, it's the relationship between the airline and the OEM that works. Gauri, next slide, please.
Right.
Yeah.
Thanks.
So
on purchase documentation, there are 3 parts to the agreement. There is, of course, the general terms agreement, which is the standard motherhood, document that goes with all purchases on that type of aircraft. So let us say, we are talking of the latest Boeing Maxes. So there is a GTA that goes with it, a general terms agreement. Along with that is a purchase agreement, which is specific to every purchaser or acquirer of aircraft, as well as there are letter agreements which provide for, special, let us say credits, which are given for purchase price adjustment. Credits could be in the form of spare parts, so they give you spare part support. So the price is therefore, reduced by spare part support, or they give you marketing support, or they give you training support, or they give you, training support in the sense of, let us say, pilots. So of course, one aspect which we haven't discussed at length is the availability of pilot and crew. And there, of course, pilots have to be certified to fly these aircraft. And therefore, simulators is an important piece of aircraft fleet acquisition, as well as crew training is. And then, of course, there is the induction cost, because every time you induct a new type of aircraft or an existing type, or you mix your fleet, there is an induction cost. So the letter agreements cater to all of those exceptions. There is also the maintenance and repair contracts, which are with the MRO, as well as the product support assurance document, which is about the Boeing or, let us say the OEM products which they provide, not the buyer furnished equipment, but the Boeing products themselves. And that document addresses what happens if those parts of an aircraft go bad. And so for today's discussion, since we are only touching upon the high points of a purchase transaction, we will be talking of warranties a little bit, delays, delivery schedule, payment schedule, which we have touched upon. Delivery schedule, which we discussed, could be moving or delayed. Payment schedule that goes with an aircraft. Price escalation mechanism, which is normally tied into a certain number that is agreed because the aircraft is produced over and delivered over a period of time. So obviously, nobody wants to absorb the risk of labor and metal. Maintenance and repair, and of course, governing law, which Richard also mentioned, is normally US law, but I think we'll touch upon those points. Namita, over to you.
Sure. Yeah. So now the next.
I think, shall we ask Kashish, how much time do we have, Kashish? It's 6 o'clock already.
I think another 7 minutes up, because.
Okay, so maybe we will cover the text, or at least the points that we want to cover, and then maybe we can respond to the questions by email. Is that fair?
Right, sir. Absolutely. We can do that.
Because I think Priya must be waiting.
Yes, she's already on board. She's waiting in the.
Okay. All right, go ahead.
Apologies, Priya. We'll wind up quickly. So the next one is on warranties. So we've already spoke about that. Warranties, basically who's standing by who do you have a recourse for? So every OEM has their own process of warranty claim, whether they can dispute, how does it change your contract. So short point, like we discussed, your OEM products are signed up, warranted by, has a warranty from the OEM, which is typically 4 to 5 years and depends on a negotiated deal. And rest of the products that you see, BFE supplier products and supply furnished products, are all direct warranty from the specific supplier. So your OEM is not standing behind them, although they might be assembling them or might be even getting them from their known suppliers. That's just the way the practice happens. Next slide, please. So this point is very important. This will tie up to your delivery schedule. So this is where so all of us know, at least in contract law, there's a concept of force majeure. So how that force majeure translates into an aviation contract is through the definition, through the concept of excusable delay. This is where an OEM gets the benefit. The first point here to be understood is that this concept of an excusable delay is not a reciprocal concept that will apply to even the airline if they cannot pay the money. No, it will only apply to the OEM if they are not able to, deliver to you on time. If certain pre-agreed events have happened, these are very standard, your typical force majeure events. Now, what are the implications of that? Now, typically how it is done is, if say an excusable delay happens between 6 months from the day you start manufacturing to till 6 months, then there will be a specific kind of point. They would say that you might have the right. Obviously nobody will terminate the contract, because you cannot terminate with one OEM and go to France and choose another. So you would have an arrangement of what is the reasonable recourse and in how much time they can give you. Now, if they shoot up and they delay beyond 12 months, now that is something everybody will look through. How is it even, impacting my entire delivery process? So you can have recourses basis commercial negotiations here. Apart from this, any other delay, there's no typical implications of any other delay that they have given here. And now moving on to the other concepts. Anand, would you like to discuss the governing law?
So I think governing law is again typically New York for state of Washington for Boeing. Because obviously they are comfortable in their home jurisdiction, and in maintenance and repair you can either do MRO contracts for the fleet maintenance. There are of course checks that happen. C checks is where there is of course a bigger maintenance, but A and B checks also happen. These are more finer points of aircraft maintenance and keeping it airworthy. There are also tax issues around this, especially with spare part management, as well as creation of a maintenance reserve, which is under a lease agreement. And I'm sure Richard would have dwelled upon it. As well as, there are, of course, the delivery schedule issues, which of course we have already told you about. So I think we'll wrap this up unless there's another slide.
There are just 2 more points done.
Yeah.
Plus escalation.
And the payment schedule, as I said, it's linked to the delivery timeline. If it gets delayed, there is a cost angle that moves with an aircraft, and there is a price escalation. Normally, it's safe to negotiate a cap on price escalation, but that cap is again something that is commercially agreed. I don't want to delay Priya more, because I think she's in Singapore and she's joining this call at an odd hour from Singapore. And just to tell you, Priya is also from CLC, just like me. So, I'll just quickly hand over to Priya. Before we do that, I just also wanted to thank our team members, Gauri, Aditya, who have worked extensively for this session. And I think with that, I just want to hand over back to Kashish. Over to you.
Thank you, sir. Thank you for detailing this aircraft acquisition build process very smoothly, sir. Thank you. And thanks to Namita as well. Before coming to you, Priya, I'll just make a slight announcement for our participants. Participants, please note that the certificate of participation and the internship opportunity that my moderator Neha Singh spoke about today will be provided only to those participants who have registered for the workshop and have duly filled their feedback form on both the days of the workshop. We will, of course, cross-check it with the attendees list generated by Zoom. An important update on the internship program is that students and participants are required to submit their own analysis of one of the topics which may be addressed by any of the speakers on both the days. And they may submit such an analysis with us by 4th of March at events@linklegal.in. I'll repeat that for the participants. It's events@linklegal.in, and it needs to be submitted by the 4th of March. The word limit on the submission should not be more than 700 words. And the internship will ultimately be awarded to 6 students, which will extend over a period of 6 months on the basis of evaluation of the submissions made. Thank you, Priya. Thank you for joining us from Singapore. I mean, welcome. And you are ahead of us in time. So it is late evening for you. So Priya, of course, is the General Counsel and Chief Compliance Officer of Akasa Air, the new emergent. Welcome. And, everybody watching the industry about Akasa. Priya has an extensive experience in private practice where she advised clients on mergers and acquisition, joint ventures, private equity transactions, government privatizations, capital markets, and general corporate advice. Now, until recently, she was the in-house general counsel of Indigo, another renowned airline, where she was part of the executive committee, apart from being a member of the compliance committee. Prior to joining Indigo, she worked with Gibson Dunn in their Singapore office, where she helped, pick up and build the Indian practice for more than over 8 years. Before her stint at Gibson Dunn, she worked with Jones Day in Singapore, a position she took after working for 5 years in AZB, a well-renowned tier 1 law firm. Priya is a postgraduate in law firm from CLC, as Anand just mentioned, and she is dual qualified and admitted to practice both in India and England and Wales. She has been recognized as the Woman Law of the Year in-house for 2021 by Asian Legal Business. So welcome, Priya, again. And I would just like to say that, in order to make this interactive, what we'll do is that we'll have more to do with the question answer kind of a session. And my, moderator Neha, please feel free to jump in whenever you wish to ask a few questions from Priya, and we'll not try to boggle you down so much.
Thanks, Kashish. Do you mind letting me take the first question?
Sure, please do.
Priya, first of all, we are extremely pleased to have you on board. I'm sure it's a huge responsibility, standing a brand new airline. We appreciate it very much. The world is watching you very closely, and I'm sure it's a great and difficult and a very responsible task. Having said that, we would like to have some views about what you feel where we are in terms of aircraft leasing and financing when looking at the last 2.5 years of COVID. How do you think the airlines have managed and their finances, their relationship with lessors, and what's your broad view on that?
Thanks a lot. Thanks, Neha, and thanks, Kashish, for the introduction. And of course, thanks, Anand. I'm very happy to be here because being an alumni of the same university, I think this is such a great thing that is being organized. I never had it in my time. So this really is great for everyone, I think, and I think everyone must be feeling it who's on the call. So that said, aviation, and I've been doing it now for close to 6 years. I mean, as you know, I was in private practice before that. And I have lived through 2 years of COVID in an airline in India. While I'm at Akasa, my experience of the last 2 years that I have to speak about will be from Indigo, because that's where I was while we were going through the pandemic and, going through the whole leasing story and how the world was unfolding in the last 2 years. So, just to give a quick summary of how it changed and what happened is pretty interesting. So, I think I haven't attended a lot of the sessions for the last 2 days, but I think one of the sort of very important things that happens in a lease agreement that we sign with lessors, and this is exactly a structure where, we lease an aircraft from a lessor, but we actually have a sort of a buying deal of the aircraft from either Airbus or Boeing. And then we transfer that right to the lessor, and then we do a lease with the lessor, right? So what is an important document that we end up signing as airlines is the lease agreement with the lessor. Interestingly, this was also, of course, very new to me when I went into aviation, is that there is no concept of a force majeure clause in these lease agreements. So there is no way you can stop paying just because you're in the middle of a pandemic, right? So somebody would think that if, the government has told you to park your by an order, so there is nothing you can do, why should I be paying for those 2 months of my fleet standing on ground? But there is no out in these contracts, right? And so at the end of the day, what you saw in the world of leasing was that you weren't flying your planes, you weren't earning revenues, and this has nothing to do with just India. This was a worldwide phenomenon where you had parked aircraft, but guess what? You were paying for them. So while you weren't earning revenues, you were paying for all the lease rentals that you had on each of your aircraft. So the larger the fleet, the more the payout, as you would imagine. So what happened, right? So there were some airlines that went bust because they obviously had to, file for bankruptcy at a time like this. If you're not making money, you have a large number of employees that an airline always needs, as you would imagine. And you have to keep afloat paying the fixed costs, which are very, very high in this industry. So what you did see was some airlines going bust, but you also saw some airlines come out looking really good. And obviously, very proudly to say, one of them was Indigo. And I was obviously associated with them. And why do I say that some came out looking very good? Is primarily because of the fact that there was, it was one of the airlines, and why I can speak about them, I'm sure there were others in the world, but why I speak about them is because of my association with them and my work during the pandemic time with them, is the fact that there wasn't a single default in any lease payment. So what happened is that many airlines just stopped paying, right? Because they just couldn't afford it. You run out of cash one day because these are all the payments that you're doing out of your entire savings as an airline, right? So everybody saves cash, and then the cash depletes really fast in an airline business. So what happened was that a lot of the money that was, a lot of the cash reserves that we had, we were able to do it. So I think what was strong and what came out of it is that it's very important to have your fundamentals very strong in an airline, your lease agreement and your fundamental cost structure that you capture in your lease, and the deal that you do with your manufacturers, exactly as I think Namita and Anand were explaining to you all as to how those OEM transactions work and what are critical in them. Those become very important at the time of trouble. Nobody picks up these contracts when the going is good. Contracts only open up when there's trouble, right? That's the phenomenon of life. So if those don't capture these fundamentals, you could live through an issue, and which people did. So how did the leasing world change? Unfortunately, not much has changed. You would imagine that airlines now saying that, listen, in each of my lease, I need to have an out to pay, and the lessor is going to agree to it because of what we've lived through. That's not the case, right? I haven't seen it happening yet. I don't see it happening. I've spent a lot of time in the last week in Singapore, just spending a lot of my time with lessors. So it's very fresh in my mind to have these discussions. But I don't think the world is going to change that easy, because the risk that the lessor is taking is very high, as you would imagine, right? Because they're buying an aircraft, they're paying a huge amount of money for it. So the fact that they're buying it and leasing it to you, there is a big risk involved there. So for them to change that completely just because of the fact that, the world has seen the pandemic and now all of us should think differently is not going to happen so easily in the leasing world. So that's just a snapshot to give you what was happening, what we lived through the pandemic. And obviously, because we lived through the pandemic, we opened up a lot of the contracts, which otherwise you wouldn't. And then what do we see now? I don't see much of a change in what we used to negotiate earlier to what we are negotiating today. It's pretty much the same structure, other than some things that may be thrown in as asking for deferral of payment in case of a force majeure, or some kind of relief if you're going through a force majeure. So that's the kind of landscape that I'm seeing practically when it comes to the leasing world.
Right. No, of course, I mean, you spoke about fixed costs, you spoke about, lease agreements, fundamentals being strong, and, these contracts only being opened when, they ultimately in times like this, when, there is a feud or a dispute. But, I mean, now we see we've lived through, 2 years of the pandemic. I mean, we can't just spill, the entire life of this industry in these 2 years, because our transformation overall has been big. And I mean, lessors and lessees ultimately, and the manufacturers being part of the same value chain, they need to move together. And so how do you think this relationship between, this interstate relationship between manufacturers, lessors and lessees have kind of evolved, or how do you see them evolving in the coming times?
Interesting. So one of the things that's definitely involved is that we speak a lot more than we've ever spoken, right? Between the three parties that you mentioned. I don't think I've ever spent as much time with OEM manufacturers as I have in the last 2 years. And when I say OEM, I'm talking about the, the engine people, the aircraft, the Boeings, the Airbuses. There has been so much of interaction over the last 2 years on every little topic that you can think of that came as a question, a mark, and what we may have written in our contracts that we have signed years ago. So these are not new contracts, right? So contracts for an aircraft are signed way in advance. I'm sure you've gone through these discussions in the last 2 days, but practically you order an aircraft much in advance than when you get the delivery of an aircraft, right? So for example, at Akasa, we've got 72 Boeing that we ordered, right, in November of last year. Am I going to have 72 aircraft tomorrow? No, I'm not, right? So these are things that go over time. So that relationship is built over years, right? There's a relationship of trust. And we know that we have to do business with each other, right? There are only 2 people in the world making aircraft. So are you going to go and tell someone that, listen, let me pick up the phone and say that, listen, it's the relationship between us is not sounding that great because you're not giving me relief. I'm going to cancel this order and go to someone else. No, you're not. So the whole mindset of the last 2 years I've seen in dealing with, so it was always a great relationship pre-COVID because, we've always done business on the same side of the table, right? We are all on the same side. There is no 2 sides in an aircraft deal, right? Because you need the aircraft, you need to lease the aircraft, the lessor needs you, and the manufacturer needs you. So given that we were all on the same page, what I saw during COVID is that everybody stood by each other a huge amount, right? So lessors stepped in to help. They actually, wherever they saw there was, the fundamentals being strong, where they saw that relationships had been built, they did step in. They did give deferrals, even though none of that was there in our contracts, right? So why did that happen? Because this was an unprecedented sort of situation in the world. And what I saw was a lot of positive sort of energy between all 3 parties, between the manufacturer, between the lessor and the airline, right? So I felt that it was a sort of a mix of 3 people working to make this whole piece a success. We took deliveries through, I think we were one of the, when I say we, at that point of time, Indigo, I think it was one of the only airlines that went ahead and took 40 deliveries on Zoom and through agents. So it was a very tough year, maybe for the lawyers and the sort of the aircraft financing team and all of us sitting in the airline. But the fact of the matter was that we did it, and we did it only because of the trust and cooperation of all 3 parties who were involved. Otherwise, it wouldn't have happened.
Thanks, Priya. I mean, that's a wonderful insight of how each party has been successful in helping each other out by, you say, deferrals to make this a success, because ultimately the business needs to continue, the operations need to continue. Might I ask, I mean, what do you think? I mean, what is important for a smooth conclusion of an aircraft lease transaction or a purchase transaction? And I mean, what could be, being in a position of a lessee, I mean, what could be sticking points for a lessee while considering these documents? Because you say that, these documents, I mean, when all is well and good, they're kept aside and, way behind in a closet somewhere, and, closets open when there are feuds. So, what do you think, as per your perspective, is some sticky points for a lessee that they should, have in mind or bear in mind while concluding these kind of transactions?
Okay, so looking at from a lessee's perspective, which is the airline, so what becomes important? So we're looking at two different contracts here. We're looking at an OEM contract, and then you're looking at a lease contract. Mm-hmm. From an OEM contract perspective, it's obviously very critical to see what are we signing up to in a very long-term contract. So there's no out of these contracts, right? So what is it that you keep in mind while you're negotiating these is to figure out that this is a marriage that has to work, right? There is no out in it that, oh, tomorrow, sorry, I'm not sort of liking this, I'm going to terminate. No, there isn't any of that option. So every little business or commercial or sort of any point that you put into these contracts is with a frame of mind that this is something that you're tied into, right? So you view the contract with that at the back of your mind, and then you see what are the issues that become important for you as an airline. And let me tell you upfront, there's not much that you can negotiate with any of these OEMs, as much as we try hard and we spend hours. And of course, I think Namita has just lived through it with us at Akasa. But I think the fact of the matter is that there are some fundamentals that we will always be looking at, right? So, for example, excusable delay. What is it that becomes what is it that can be an out for the aircraft manufacturer? Does that impact you? What is it that is something that you may want an out, or you may want a deferral, or you may want an advancement of an aircraft delivery, or at times you need a deferral of an aircraft delivery? How many months in advance you have to give notice? Because at times you may have to do it very close to when your aircraft may already be in the process of being manufactured. So there's some points that you sort of think from. Actually, not some, all of them are driven by what the business needs, right? And how you may be able to delay or advance, or, I mean, it may not be a delay or advance, but even the fact that if you take delivery, what are the few principles that need to apply on that particular date, right? So when you're looking at that from a manufacturer's perspective, then you also need to capture that in the lease, because at the end of the day, you are now then leasing this aircraft and paying a rental on these aircraft. So what is it that now I need to change my mindset to? What am I thinking vis-a-vis a lessor? Again, the first thing I would want is a force majeure, but I don't get it. So let's be upfront about it. But the second piece that you would look at is that, okay, I've taken this aircraft, I lease it for a couple of years, right? Leases run from 6 years to 12 years to 15 years to 9 years. It all depends on different airlines and what they decide. But what are you looking at? You're looking at that asset with you for a particular number of years. Now you've got that. You've got to redeliver it at a particular time. And in all of the time that the aircraft is with you, you're going to fly it. You're going to do checks on it. You're going to send them for maintenance checks. And all of this costs money, right? So what do I map when I sit on a lease? What do I map with the business team? I sit and map what is my cost outlay for 9 years. That's what's fundamental. So it's not really legal, but I would think it's more commercial. And being a sort of in-house aviation lawyer, you'd start thinking more business than law, because if you don't have that fundamental, there is no success to any of these agreements. So you actually plot it. You plot on year 6, this will happen. On year 3, this will happen. On year 8, this will happen. So what is your outflow of money overall? One is paying your lease rentals, but there are also other maintenance money that you're paying a lessor. So those are aspects that you'll keep in mind while you're negotiating this lease. And then, of course, when you have to redeliver. So what happens is that after a particular number of years, these aircraft go back to the lessor, and then they remarket this aircraft to some other airline. So your story ends with them, somebody else's story begins, right? So when you're returning it, they're very particular on many conditions that they set forth in the lease itself. Now, it's very easy for me to sign up today and say, yeah, I'm going to do this. And this list is of some, annexures that run into various points. But each one of them has to be thought through, right? Can I actually be doing this? If I agree to a particular, so let's take an example, right? I've put in a certain configuration in my aircraft as a CASA that I want seats that are going to be put like this. So you'll see aircrafts which are 323, 33, 222, you can have any configuration of the way it works for a particular airline or the seat style, right? This is just an example. And then when you return it, the lessor says, no, I don't want this 222, which you all liked as a CASA. The world doesn't like a 222. They usually like a 322, right? So guess what? When you give it back to me, I want it as 322, not as 222. So who's going to pay for it? So these are questions you'll ask yourself at the time that you sign it, though it's only something that will happen 10 years later. But I have to take that cost implication on my self when I'm signing that lease today for a return after, say, 10 years, right? So they're mostly commercially driven, but obviously all of it ultimately is put in a contract. And if that contract doesn't look good, you're not going to get anything when you open up to, see if there's a battle to fight on any of those points. So that's how I would view both these contracts.
I mean, you're absolutely right, because you highlight two essential requirements, and those are, what do you need to run an airline? I mean, the two key takeaways that you point out are, one is fleet, and of course the other is maintenance. Because ultimately, an aircraft, when a passenger, every one of us flies, it's all about experience. We often than not, have apps now, everything we can, tag and see what kind of an aircraft I'm sitting in, what model is it, what year is it, but more than that, more often than not, the ultimate value to the customer that an airline provides is the experience. And you're absolutely right on that. Neha, you want to jump in here?
Yeah, I was just going to say this. These are like very nuanced things that do not, it wouldn't occur to anybody and everybody. Even if we are lawyers in this sector, you have an experience in-house, like you said. You know how to look at things commercially and how to manage them. You have to look at things 10 years hence to be able to factor it, into your leasing. I like to take some of the questions that are coming up from the students, Priya. Can I take a couple of them?
Of course, I'd love that.
So there is one coming from Suman R, and she's asking, very curious about a CASA sale and leaseback arrangements. If you could be kind enough to share any, thoughts on the sale and leaseback model.
Yeah. So a sale and leaseback model is not something new to ACASA. It's an industry practice that goes across airlines around the world. But so what is a sale and leaseback model? So what you do in a sale and leaseback model, just to get to, I know it's going to sound really sort of very babyish and very fundamental to many people on this call. But so what you typically do is you negotiate so let's take an example that what a CASA may have done, right? So we've negotiated a deal with Boeing to buy a particular number of aircraft. Now, frankly, there are people who just go buy that aircraft and put it on their books. There are many airlines who do that. There are many airlines who go into a sale and lease back. So you can choose to do both. I don't know which way ACASA will go in the long run, but let's say that, there is a sale and lease back. I've seen airlines and I've been in airlines where they've been doing both. You do a sale and lease back and you buy aircraft. You do both models. What is the difference, right? So when I do a transaction with, say, a manufacturer, there are only two in the world, but either of them, I decide to buy the aircraft, I can pay for the aircraft, I negotiate a price, I buy it, I bring the aircraft and it becomes mine, right? Now, what if I don't want to put all the money up front to buy that aircraft, right? So an aircraft is not cheap, as we all know. So I may not want to be out of pocket and send all of this. So a sale and leaseback is some mode of actually, in some sense, financing of the aircraft for an airline. So what you do is that you say, guess what? I may have bought this aircraft, but now I'm going to, take it out of my book of buying this aircraft and give it to a lessor. Who's a lessor? A lessor is basically a financing company in simple English, right? So there are all kinds of lessors, there are all kinds of names out there. If you ever Google it, there'll be those first top 3-4 that will always fall. But it's an interesting thing to read if you ever Google it, right? Who is an lessor? Why do they take this risk of an aircraft? Because these guys are funded leasing companies, right? So they are leasing companies who are in the business of doing aviation leasing. You have banks who have arms who do it. You have GE, you have Stanchart, you have, the BBAM, the GoShocks. These names are going to sound sort of like French to you all, but if you ever Google them, they're the names that will always come up. They're heavily funded financing companies who then go and actually pay for this aircraft. So I say, guess what? I'm not paying this X million dollars to the manufacturer. You pay for it. and I will then lease this aircraft from you. So why would they do it, right? Because A, they've obviously, get lease rental from us, which will always be a percentage of interest that they make on the money that they put in. But you also see that they have committed to buy an aircraft only when they have a commitment to also lease that aircraft, right? So for them, it's in some sense, there's no risk. They're not just buying the aircraft and marketing it. They can do that. Lots of them do it. But this model really means that I'm buying it and then you've got to lease it from me. So I, as the airline, have now passed my risk of buying to someone else, but I have taken on the liability to pay a lease rental to someone who funded this aircraft on my behalf. That's really what it is. If it answers your questions, I'm very happy to get a follow-up question. But simply put, this is the structure, and this is the structure for every airline.
Absolutely, Priya. Understood. I'm sure it was absolutely clear. We are running absolutely short on time, but we'll take just one more question coming from Atul sir. Atul sir, you can take your question.
Okay, thank you, Priya. It was really wonderful to have you on this seminar. But of course, a typical contentious lawyer, I can't hold myself asking you a very basic question about hell or high water. Now, when pandemic came, we had thought there'll be evolution of law on force majeure in India. It was such a big letdown. We never had any, jurisprudence evolving on force majeure in the typical conditions, which were never foreseen by any of us. Do you really see, because, and in reality, from looking at it from the business perspective, the real thing which has happened is that the lessors have taken haircuts, because that's the most pragmatic way of looking at the business. Do you really see that going forward, this could be a lesson where the industry, in fact, the financing and the leasing industry would recognize this typical situation and come out with some mechanism wherein in peculiar circumstances, this can be dealt with?
Thank you for the question. And, it's very interesting, Atul, that I have actually been in Singapore for the last 10 days, and we happen to have the air show here during the last week here in Singapore. And I must have met close to 12 different lessors as we speak today in the last 1 week. And this is the one question that I have asked each of them, that, this needs to evolve from what we've learned, right? And that lessors have to see this a bit differently, or, put in a structure, or put in some kind of a safeguard which actually protects airlines, because we've seen airlines go down, right? On just because of a clause like this that exists in the contract. And it's interesting, but I think the entire response that I get, and this is not just India related, I'm talking about China, I'm talking about Indonesia, I'm talking about Singapore. The reaction has been that, guess what? A, not many airlines have brought it up. And two, if an airline is going to bring it up, we just won't do business with that airline, because we are living on a very high risk when we do this transaction, or when we buy these aircraft on our book to, lease them to airlines. So the immediate reaction is that, no, we're not going to see a change in this clause. And guess what? We are not going to ever change this clause. And though we may have lived through the pandemic, we were very good. We gave people a chance to defer. We gave people a holiday for a couple of months. So, and guess what? There were some airlines who didn't pay, and we know some of them exist even in our country, and nobody came to repossess an aircraft. So my question to them was that you didn't enforce a particular clause that you all fight so much upon. And they said that, we may not, it's all depends on, can we remarket the aircraft, right? So I may pick up the aircraft from you today because I want to enforce this clause, but can I remarket it? So we can't. So in some sense, that clause may exist, but we didn't enforce the clause. And that's how life is going to continue, right? So they're very happy to have a conversation with you if you ever need their help, or if you ever need to come and have a conversation to defer, or a conversation to give them a break or a holiday. But they're not going to look, nobody out of these 11 or 12, the top 10 who we will anyway do business with, are looking at any involvement in this clause. So for me also, it was, as a lawyer, a question that I raised to each one, because it's something I've lived through, right? So, and very, like you put it, you would think that something like this would evolve just from our learnings from the pandemic. But unfortunately, I don't see it change immediately. Though, let me tell you, I'm going to fight for it in each of my leases going forward. I don't know if you're going to get it. But the point is, it's definitely going to be brought up. And let's hope at some point, like you said, it doesn't have to go away, but there has to be something built to give the comfort to both parties, is my feeling too, also after COVID. But as of now, I don't see a change in the market at all as a business person.
One more question,
Yes.
which is also a very pragmatic question. I'm sorry, Neha, I'm taking a little more time than I had committed. You see, in the context of operating an airline in India, I mean, for a foreign airline, it's fine. They fly in, fly out. They don't have just 2 flights a day. And that's the end of the matter. But then there is such a close interface between the infrastructure, the airport infrastructure, and the airline. Particularly, you're going to, at some point in time, you will have 40 flights, 50 flights a day, 60 flights a day. And I'm sure you will achieve it. One thing which has actually impacted the seamless working of the industry has been the conflict between the airlines and the airports. And now ERA has become more of an instrument of creating disputes rather than resolving disputes. You know, prior to that, you would just have an agreement with the airport and negotiate it on a commercial basis and, you know, take the facility. And I'm even surprised because unfortunately, many a times we, at least our firm as lawyers, have been conflicted in 2 kinds of situations. You know, kind of we are representing an airline on the one side and then an airport operator on the other. And then you realize that the whole stakeholder conflict has assumed such a contentious, character. Do you believe that once you come into being, you should be looking at a more collaborative approach in terms of really doing this interfacing in a seamless manner without wasting so much of money, time? Of course, I'm talking against myself as a lawyer. This is business for me. But then from an industry perspective, do you really believe that time has come that as airline industry, you start looking at it in a different light?
Yeah. So you're absolutely right. You know, I have lived through a lot of it myself, from doing litigation and spending, I don't know how much, on just trying to fight the ERA, and the airport operator gets involved. And so I have seen, so forget what it will be for Akasa, right? And I can tell you upfront that there's a complete collaborative approach that has been taken in this airline, right? As we start, it is being seen as partners in it together. That's the only way to achieve it, right? So you have many new players, as you know, in the airport space itself. You have many more private players in the market. All of them are very open to have a very, very collaborative conversation. That itself is extremely helpful as we start. But this is talking about an airline that's starting. Our approach will be very collaborative. We've got that kind of collaboration already when we speak to the airport operators. But that said, let me tell you, even in my past avatar, which is not very old, and the fact that I was with another airline, I had seen the change in approach in the airlines itself, who've been doing business with airport operators for the last 12, 13 years. And why did that change come? I think that change was driven with the fact that, am I going to be litigating against people who should be on the same side? If you don't have the infrastructure, you're not going to get the parking slot. You're not going to be able to fly, as you said, these 50, 60 flights in and out of various airports. Of course, we're talking about 50, 60. I was in an airline which had 1,500 flights a day. So if you didn't collaborate with them, one fine day, it's not going to make commercial sense for either, not for us, not for the airport operator. So I saw a big change and big shift in the last couple of years, even in airlines that have been in existence for a long period of time. The whole approach was, let's do business together. And that's become so much easier in the sense of this whole change of even getting some of the private players in. because they're also commercially driven to do this. They're not doing this because, guess what? I want to see my name in an airport. Lots of people like that too. But the fact is, if it doesn't make commercial sense for them, they're not going to put in the investment time, money in it either. So given that it's for both people, it's commercially driven, I've seen a huge shift in the fact that this is a collaborative effort across the country. It can't be just one airport. It can't be just the major airports. I think we have to see it across the country in tier 2, tier 3 airports. And I can tell you, Abdul, that I'm feeling the sense that it's very collaborative. And that's what we've been definitely seeing, at least at Akasa. Maybe we're new and everybody is, sort of ready to have a conversation. But I do have to say that it's not only something that I've seen here in the last 3 months. I also saw the shift in an airline before this. So definitely a positive shift.
That's heartening. That's heartening to hear. Thank you so much. Thank you. Really appreciate your answering these questions.
Pleasure. Thank you. Thank you for having me. So,
Neha, back to you, or Kashish.
Thanks, Priya. Thanks. It has been an incredible session. And like I said, you are the industry yourself. And you speaking on the event, after the insights given by, lawyers who are really not into the industry part of it, makes so much sense and gives us the right kind of insight. So thanks for this session. It has been incredible.
No, my pleasure. So really enjoyed it. And if there are any sort of questions that you'd want me to answer later, I'm very happy to do any of that. So
thanks, Priya.
Thank you, Priya. Thank you so much for being a part of this.
Thank you. Thank you very much.
So we move on to our next speaker. Professor Jeffrey Bull is the Secretary General of Aviation Working Group, a not-for-profit international industry group that works on the development of policies, regulations, and rules designed to facilitate advanced international aviation financing and leasing. Jeffrey acts in the capacity on secondment from Holland and Miami, where he is a partner and the firm's director of international loan policy. Jeffrey coordinates all AWG activity and has since its inception in 1994, previously doing so on secondments from Perkins Coie, where he was a partner of Freshfields, where he was head of aerospace law and policy, and Lease, New York. Jeffrey is a senior research fellow at Harris Manchester College, Oxford, and an affiliate member of the Law Faculty, University of Oxford. Jeffrey was the second instructor of the now globally instructed course, Transaction Commercial Law. He then led the initial development of its course material and was key to its advancement. He is a senior advisor to UNDUA and president of the UNDUA Foundation. He was Camden Paltner Professor of Global Business Law at the University of Washington School of Law from 2011 to 2019, where he was the founding co-director of the Global Business Law Institute and developed new courses on international business compliance and comparative commercial law. On behalf of AWG, Jeffrey has been central actor in development, negotiation, and national ratification and implementation of Cape Town Convention. He chaired the group that prepared the initial draft of the aircraft protocol, chairs the International Advisory Board for CTC's International Registry, and is the director of the Cambridge UNDUA CTC Academic Project. He leads global projects promoting and assessing ratification of and compliance with CTC. Jeffrey has also coordinated the development by AWG of GATS and ESG initiatives. I have known Jeffrey for a very long time, and if there is one person who you have to listen to across the globe when it comes to aviation law, framework, and policy matters, it is him. And this workshop would have been incomplete without his participation. It is an absolute pleasure to have you with us, Jeffrey. And before I hand over the floor to you, our managing partner, Mr. Atul Sharma, would like to say a few words. Jeffrey, I think you'll give a concluding remark. Why don't we start? It's absolute pleasure to see you here. Thanks for taking the time out.
My pleasure. May I just ask about acoustics and visual aspects? Can you hear me and see me well?
Yes, absolutely.
Okay, well, I'm not sure that's good for you or not, but maybe a bit better if I'm blurry and hard to hear. So, but I'll try my best to.
I missed out. There was, my apologies, Jeffrey. Neha, you asked me to say something and there was a problem in my system. Sorry, Jeffrey, to interject, but I wanted to say something. And that is, thank you so much for, accepting this invitation. And of course, you and I worked together for a while, a few years ago, as a part of the aviation working group. And of course, Neha was also a part of it at that point in time, along with Ravi. Well, I just wanted to thank you because this is such a critical component of the entire business. And we will be really happy to have your views on this topic. Thank you so much. I thought, I'm again apologize for interjecting, but I had a communication problem there.
Okay. Thank you both. I'll just continue if I may. First, I'd like to thank deeply those responsible, Neha, starting first and foremost, but everyone involved from Link Legal and the University of Delhi. It's a great pleasure to be here. I understand that approximately 75% of those involved are students, and I am going to, despite the quite sophisticated conversation that just preceded me, on which I may add a few words if I could, I will gear this towards students. And I think, having looked at the impressive program, impressive list of speakers, I'd like to, as this is one of the last talks, tie a few things together and lead into the Cape Town Convention, which is appropriate given its sweep and its relationship with national law. And so I think, just from a student's perspective, I'd like to take a bit of a broader look than the technicalities of the Cape Town Convention. So I'll do that. I'd like to start with a few words about. You could put the previous slide. It's going to take me a while to get here, so leave it here for now. So I'm going off script a bit to put this in context. I'd like to say a few words about commercial law and transnational commercial law, of which the Cape Town Convention is perhaps the exemplar in aviation and generally. But I think it's best. One best understands the Cape Town Convention by taking a step back and saying a few words about commercial law generally and the law that would govern an aircraft finance transaction absent an international treaty, basically what India and most countries have faced prior to their ratification of the treaty, and then understand what went into the Cape Town Convention and its core terms before really looking at the precise situation in India today. I think for students, it's important. I think the starting point when I teach commercial law and transnational commercial law is to start with the basic question: is the purpose of the rules to facilitate the type of transaction, or is it more prescriptive to regulate the type of a transaction? And when we are dealing with sophisticated parties, aircraft finance transactions, but clearly we're in the category of facilitation. That does not mean that there is no role and limit to kind of a regulatory aspect, but the essential feature is to facilitate the type of transaction. And we're going to come back to that when we talk about the principles of the Cape Town Convention. A second starting point is the distinction between contract and property law. And I think it's always worth going back to that very basic point. Broadly speaking, parties have a large sphere of party autonomy in India and around the world to choose the law to govern their contract. There are clearly some limitations on that. There were very interesting comments made about this in the COVID context, but broadly speaking, the direction of travel is towards party autonomy and the ability to pick your law. Property law is another matter. The question of what rights you have in assets and what you can do with those assets and the competition between conflicting interests in that asset, and above all, what happens in the insolvency context where there are it's a zero-sum game very often, and there are winners and losers, is really the acid test for understanding commercial law. And I think the basic principles, as well as ones that arise from the international nature of aircraft finance, which give rise to an added layer of interest and complexity, especially on dispute resolution. Many cases, as people on this call know, have been decided in London courts involving Indian Airlines, and that is because of the particular nature of that. So, in thinking about commercial law, one really needs to look at its purpose here, facilitation among sophisticated parties, the distinction between contract and property law, and the reasons why there's sensitivity on property law, insolvency above all else because of the policy issues implicated for society, but the very real risk elements that are present. And I will again come back and comment on Priya's observation. And I guess I should at this point fully disclose. I know people here probably have clicked a few buttons already. The Aviation Working Group is made up of the largest leasing companies, almost without exception, around the world, and manufacturers and financial institutions. And so, and I'm not speaking for the AWG, I'm speaking for myself in an academic context, but I will come in a bit on a few of those points that were made in the context of what Cape Town was meant to do, including in this kind of a context of allocation of risk for unforeseen circumstances. And so that the starting point is sort of commercial law. The next header to address is the transnationalization of commercial law, transnational commercial law, TCL. The transnationalization of commercial law is an attempt, broadly speaking, with various features and approaches to either unify or harmonize to a greater or lesser degree aspects of the law applicable to transactions with international features. And over the years, there have been a range of efforts and instruments to do that, starting with soft aspects such as principles, to things like model laws, to the heavy artillery in this area, which is a treaty. A convention and treaty is the same thing. And a treaty is so important because here, the country itself is binding itself as a matter of international law to all other parties that sign the treaty. Violations of the Cape Town Convention are violations of international law with all that follows from that. And so moving to this heavy aspect to deal with aircraft finance transactions takes these questions into a different zone. I know that there was some discussion about private international law and the Montreal Convention, some similarities there. The rules that apply to liability law in aviation in India are very different than that apply to non-aviation because of the presence of the Montreal Convention and its predecessors. Certainly the same for commercial law and aircraft finance and leasing, which is mainly governed now by the Cape Town Convention, as I'll come to. When transnational commercial law is developed, and now we move away from facilitating transactions to regulating them, now we're dealing with different legal systems and kind of the complicated international transactions. And there really are three types of objectives, candidates for the motivating, animating force behind transnational commercial law. One is some form of balancing legal systems, common law and civil law, and those of developing and developed jurisdictions. And in life, it's often good to balance things and to have symmetry and sensitivity to how other people look at things. But sometimes balance practically results in abstraction. And abstraction means that there are not clear rules that parties can rely on at the time they enter into risky transactions. And I'll just come in on what Priya said without, again, I'm sure that maybe all of the people she spoke with last week are in the AWG, but I think that the concept of having clear rules rather than standards and rather than evolving norms, argument about that. But the commercial side of it is that, and I think from a creditor's perspective, when the rules are clear, as they were under Cape Town in the COVID context in India, the clarity of those rules permitted the lessors to do a lot more than they would have done if the rules were not clear. You know, knowing your rights and really having a pretty good sense of what would happen in court allows people to calculate their risk. Creditors tend to make worst case scenario assumptions. And when you have uncertain outcomes, you will see more conservative behavior. And I could give my too many years in the industry, can cite many examples of aggressive creditor behavior in the face of uncertainty. Think Swiss Air and Sabina and other cases in which there were real questions about what would happen, and therefore, creditors moved to act before because it was unclear what would happen in insolvency. And so, I would just say that the kind of counter to Priya's understandable aspiration here is that clear rules provide a nice frame for negotiation, renegotiations, and concessions, as was really seen in the COVID context. I'll leave that point alone there. But once you start to balance legal systems and have abstractions, then often you lose that. A second candidate is reducing transaction costs by simplifying things, avoiding conflict of law analysis, again, which besides maybe helping some law firms because of its complexity, does increase transaction costs and does leave open a much wider range of potential outcomes that have to be assumed. And the third, which really is the Cape Town Convention example, is to facilitate the transaction type. As I said before, Cape Town was purposefully designed to facilitate secured financing and leasing of aircraft. There is no question about that. I speak with, I think, complete authority on that point, as the point person from the beginning on this. That was the purpose. The Aviation Working Group with IATA, we took joint positions with the Airline Association for 5 years. We never had a different position for 5 years, and our joint position was that every provision of the Cape Town Convention, individually and the treaty as a whole, needs to be assessed against the criteria of its ability to facilitate financing, increase the availability, and reduce the cost of financing. And so Cape Town really was a deal, which was more clarity and predictability based on accepted international practices in exchange for more liquidity and a loosening of credit and better terms. And that can never be forgotten because it is the architecture, and everything is understood really by seeing that. And so the Cape Town Convention is purpose-built for that purpose. It is certainly a rules rather than a standards-based instrument. It focuses on ex-ante efficiency and predictability rather than ex-post dispute resolution. It is quite comprehensive. It does not displace all national law, but it displaces a lot of national law and does so on purpose, again, seeking best practices and best principles. The Cape Town Convention, I think, can fairly be stated, is the most successful and certainly the most impactful commercial law treaty ever. And there are over 80 ratifying states. There are, I think, 1 or 2 treaties that have a little bit more, but those are much more elective. Cape Town is mandatory. So if one looked at the actual impact of the treaty, can't be questioned. And one has to also remember, when the treaty was developed, India as well as Russia, China, Brazil, were really coming into the aviation industry space. And there really was a desire to have best international practices for those countries. And that really was a motivator early on. And so kind of with that, I'll kind of turn to Cape Town, but keep this slide, please. So what now, applying a bit of what I said, the Cape Town Convention seeks in a sweeping way to I've lost the picture of myself, which is a good thing. I just want to make sure you can still hear me. Please confirm.
Absolutely, we can hear you.
Okay, much better to hear me than to see me. If you have to
No,
hear me.
we can see you, Jeffrey. We can see you. We can hear you.
Okay. Because I disappeared from my screen, which is good. At least I don't have to see myself. And the Cape Town Convention did approach the questions that I've said in a comprehensive way. It deals fundamentally with property law, which is the sensitive area. It deals with insolvency, which had never been addressed in a treaty prior to the Cape Town Convention. It created hard substantive law on the creation and effects of property interest and enforcement. And it did so in a mandatory way based upon very cutting edge principles like the use of a high-tech electronic registry, which maybe now seems natural, but rest assured in the late 90s, it was anything but that, and it was very controversial to move to electronic systems. And it did so with great, if I could use the word, great elegance. I mean, if you read the treaty, the simplicity in what it takes to create an international property interest. You need to do 4 things, simple, basic steps, rather than the types of things that might be seen around the world, conditions being added to create the interest. To perfect the interest, to give it effects against third parties, all one needs to do is make a notice-based electronic registration. The priority rules are as simple as they can be. First to file wins. And there are very few exceptions to that. And the main one is for government creditors, of which I'll say more in a bit. But overall, you have in this thing, and as students, I really would encourage you to read it. Read the treaty, not only for its content, but for the elegance of it. Professor Good, leading authority in the world on commercial law, and someone that I had the great pleasure to teach with for a long time, chaired the drafting committee, and it is concise. It has a common law tilt, let's say, but it incorporates a lot of civil law concepts. And it is simple and clear, and you can learn a lot in your practices and in your thinking by reading that. It's well worth it. And so the treaty is important. And now I'll get to my PowerPoint, and just a reality check. Yeah, I know I started 15 minutes late. When would you like me to stop? Just give me a number of minutes, and then open for questions. So just tell me the number of minutes, and then I'll stop at that point.
We can go on for another 20 minutes. Yep.
Okay, I'll speak. Okay, I'll speak. I have some conflicts myself coming up. I'll speak a bit more, and then we'll open the floor, because I do want to make myself available to the students to answer anything, including anything addressed throughout the last 2 days, even though I didn't hear it. The Cape Town Convention, and now you can go to the next slide, please, or the first slide. Okay, so I think I've already covered 1A. That's all I've covered, really. But I'm going to give a little bit of a background. I am going to talk about compliance with the treaty, which is really important. It's something that people don't look at, and talk about economics a bit, and then I'll turn straight to what's happening in India. Next slide. I mentioned all this. I think the point to really understand, I think, here is there are 83 countries that have ratified. India, of course, is one of them. A lot of work went into the ratification and the implementation of the treaty. I mean, I had the pleasure. I think I've been to India maybe 15 times on this and related things over the years. It's been a great pleasure, and I miss it very much and can't wait to come back. And many colleagues on this phone are dear to me, and really India played an important role. And it was a hard treaty, to ratify because it's so powerful, and it took a lot of consensus building and socialization, and we had a lot of real experience in regulations and in SpiceJet and in other cases, which I'll come to in a minute. But it's very important. It's very impactful. One should make note of the dates. As I said, it was things were a lot different in India when the treaty was negotiated in the early 90s, and it was a different industry with different characteristics, and no doubt the question was attracting finance. The government's role in the industry was it's still evolving, of course, but it was very, very different there, and it does make sense to look at things with some perspective. Next slide, please. I wish to, because I'm not going to go into every detail of the Cape Town Convention. What's really of overriding importance now is compliance, and by that I mean government compliance with the obligations that they've undertaken. And by compliance, we mean, and the AWG, we have an index where we assess and rank all countries on their compliance. It's a predictive index, as we'll see. But by compliance, we mean that the short way to put it is it would be reasonable for parties to rely on the terms and intent of the treaty. It's one thing to just have a treaty or have a law, but if it doesn't work in practice, if it's changed for whatever reason, and I don't want to comment on whether it's good or bad to reinterpret or change law. You could probably guess what I think about that, but I think it's clearly the case that if a treaty is not fully implemented, so it has the force of law and it prevails over conflicting national law, then it's not reasonable to rely on. And so much of the work that we do around the world on a daily basis is to ask India and Russia and China and every other country that ratified to keep their treaty obligations, which they've made, meaning that they comply with the treaty and that they have sufficiently complete implementing rules and regulations so that as a practical matter, government officials, courts, and authorities can take action. They have the information to do that. And so our index seeks to help incentivize that compliance and to help investors take a view on whether it's reasonable to rely upon the treaty that's been ratified. Next slide, please. I'm not going to spend much time on this. You could find all this on the AWG website. It explains, again, from a student's perspective, I would encourage you to read what might be a bit of a terse document. There's a document on the website, the methodology for our system, which explains, next slide, please. Okay, hopefully the formula is up there. Okay, so this is the formula we use, and there's a lot packed into this. And if you look at the methodology, you can learn a lot. So this index is meant to predict the next case, what is the probability that the treaty's terms and intent will be accurately followed in the next case, and that is the way we approach it. And the first half of the formula, A and B, are, let's call it directly relevant law. So A has India, applies to everybody, have they implemented the treaty such that it has the force of law with priority in the case of conflict over conflicting law, with sufficient completeness to give decision makers information to take decisions, accurate decisions. And B is what's happened in practice, actually, cases and controversies. The last 50% are more predictive, and they deal with, and this, we designed this formula ourselves. It was very bespoke. They deal with political risk. They deal with existing principles of Indian law for gap filling. It deals with whether they qualify for the OECD discount, because that then provides a further incentive to comply, and whether the government has established a communication channel to work with us in problem solving. But take a look at the methodology, because it really explains the heart of law and law assessment from a financier's perspective. Next slide, please. Next slide, if you can. Okay. Yeah, I'm going to skip over these. These just explain the variables. Next slide. This is as mentioned in the bio, I'm on the faculty at University of Oxford, and now we started a project with Unidwa and the EWG on economic assessment of law reform, and so this chart really looks at questions of risk reduction and political risk, and how those are key. This project is under the umbrella of those projects, those institutions, how they could reduce risk. And I think the key point here is variable D, which is whatever benefits a treaty may have, A, B, and C, risk reduction, if the treaty is not followed because of reasons of political and institutional risk, then the value really just goes down to zero. Then the law is abstract. And I say that as I lead into the India case. So when we look at what's happened in India, I think it's against the backdrop of to what extent were treaty obligations or are treaty obligations being and expected to be complied with in the real world. Next slide. I won't say much about that, except, and I'm sure you've heard in the other talks, that one declaration in particular, there are two that are particularly important. Declarations are choices that are made at the time the treaty is ratified, and India made excellent ones. But two of them that are particularly important are the one dealing with bankruptcy, and India opted into so-called Alternative A, which is a very clear rule as to what happens to assets in bankruptcy, that provides predictability and certainty. Can be negotiated and changed by the parties, often is done, but it's a clear rule rather than a stay on enforcement. That policy decision was made by the Indian government. It's not open for discussion now. It's been made, so the question is only whether it's followed in practice. And the system for deregistering aircraft. I'll say a few words on that. Next slide. These slides, and I think you'll have access to them, they show that the rating agency is not just, most transactions are still leasing transactions in India, but the wider aviation community, sophisticated community, the rating agencies really do look very carefully as to whether the treaty is properly implemented and complied with. Having a treaty without compliance is really a null set. Next slide. Next slide, please. Next slide. Just more of the same. The OECD. There is a discount available to airlines who use export credit if the country qualifies. India currently does not qualify for reasons I'll come to in a moment. And we have been working closely, and I think we're getting quite close. We only have one more important thing to be done, I think, for India to qualify. We're almost there, say 90%, but we need to be 100% there to qualify. It's binary. But the OECD and international export credit there is a 10% discount if a country is eligible and is on the list. And we certainly hope to see India on the list soon. Next slide. Okay, so India. India ratified the treaty and it made all of the right declarations, that is, the ones that were designed to facilitate aircraft finance. Those include court timetables. India is known to have lengthy and protracted court proceedings. India has made a decision and has committed itself to agree to timetables in connection with certain judicial proceedings under Cape Town. It's agreed to non-judicial remedies. It has agreed to a simplified one-party system for deregistration of aircraft. It has agreed to choice of law freedom. And most importantly, it's agreed to Alternative A, which basically says that there is a maximum time period, as India ratified, of 2 months before aircraft should be returned or debts should be cured unless the parties agree otherwise. So India did this all perfectly, the ratification. Next slide. These are the key things that happened over the years. And you'll notice that a number of these happened quite a bit after India ratified. So there was a long period in which a number of necessary rules to implement and comply with the treaty were not present. But we've gotten there with one overriding exception, and they're listed there. Regulations were promulgated consistent with Cape Town under Rule 30 sub 7 and 32A of the Aircraft Rules 1937. Standard operating procedures were issued for deregistration of aircraft. Real progress was made on export in regulations from the Reserve Bank of India, and then the Civil Aviation Authority kind of swept it all together in June, 15 June, with even tighter procedures on recordation. All that is really, really good. Great news. So the declarations are great. The implementation's been great, with one exception, slide 15. So slide 15, as everyone on this call knows much better than I, in India, it is necessary for there to be express primacy of the Cape Town Convention over conflicting law. We went through years of discussions about harmonious construction and how courts should try to get things to work together. Of course, they should and they will, but they won't, because there are straight conflicts, and there's a straight conflict between Alternative A and the automatic stay in insolvency proceedings. There's no way to harmonize those. And so what is needed is primary legislation to make sure that Cape Town prevails in the case of a conflict, in particular, to the extent of any inconsistency with the, quote, new Indian Bankruptcy Act. And so there's been drafts of legislation floating around for years. I know that we have a very good draft that's in circulation now, and we hope that we could all together push that over the line. That would produce substantial economic benefits. It would make India eligible for the CTC discount. There may be another way or an element to do that by a central government declaration under 14.3 of the Insolvency and Bankruptcy Act, exempting from the automatic stay Cape Town provisions. But this provision, this is the most important point. I know I'm speaking to students here, but if I were speaking to government officials and practitioners, it's all about slide 15 as far as the future is concerned. Next slide. This is a way to synthetic summary of what's happened in court over the years. And I should say the starting point was when before Cape Town applied in Indian courts, but that's more historical. But since India ratified, good decisions in SpiceJet, upholding Cape Town generally, referring to India's international law obligation, even if there wasn't the primacy rules, but did rely upon existing Indian regulations on deregistration to justify Cape Town consistent outcomes. Then in JET, before the insolvency, there was a number of kind of tangles with the civil aviation authorities, and that gave rise to close work between AWG and some people on this video to come up with the above mentioned rules, which are really good. When insolvency took place, the court did impose a general insolvency stay, which caused a problem, and it worked itself out given commercial reality. But it is a problem. It's a legal problem, and parties will need to assume that problem unless we could pass the primacy legislation. So with that, I'll stop. I thank you all for bearing with me, and especially at the end of the conference. And I'm open to any question on this or anything else in the aviation finance space, which you'd like my careful views on.
Thank you, Jeffrey. This is very, very insightful, and I'm sure you would want to respond to Priya on multiple points, considering, of course, every single lessor, is a member of AWG, and you work with them so closely. But there are some questions coming up from students. If we could take a few.
Of course, and I prefer, if there's a limitation on time, I prefer the questions from the students, please.
Yeah. So okay, we'll just take the questions from the students then. Okay. So the question is from Anulekha. She's asking, so where is India in comparison to other developing economies in the scoring on the CDC compliance index?
Someplace in the middle. And if you go to the Aviation Working Group's website, I think there's a public and a private part. The public part gives scores, so you'll see where India is. India is someplace in the middle, maybe against the word was developing countries. But I could say if India passes the primacy law, it'll be high, because as I said, through all of those actions that were taken, there really is, and the court cases, the way they've worked out, there really is only one problem left. So with this one change, we would expect to see a very high score. So it's it's on the high side of the middle among developing countries. I wouldn't call them developing countries, but with this one change, India would be high. So lots of good news. One and only one thing to do. And I would just say one thing, and again, there are probably a lot of lawyers here, from other firms. I think the work that's been done collectively, again, Niaz was involved, and her colleagues at Link Legal, and I'd be remiss not mentioning Ravi Nath from RNC, who coordinates the India contact group. All the main lawyers are involved, and a lot of the airlines have been involved, and there's been a really a cooperative approach, and it's really important to do that, because in the grand scheme of things, it is penny wise and pound foolish to try to take advantage of something. It may you may have a client and you're under pressure to do that, but that same client may be in bankruptcy, and a month from now they may come out of bankruptcy and they may want to borrow money. And so this is rule of law thinking, and we pitch it high. So it's really been a great experience working with India. I'd say, again, we have one major problem outstanding, but all in all, it's been a great pleasure, including with many people on this call, including some government officials, and you know who you are.
Absolutely, Jeffrey. Yes. And I'm sure the government and AWG and everybody else is working to sort that out, and I'm sure it will be. Another question is from Prakriti. She is asking, a CTC bill was introduced in 2018, however, nothing seems to have moved. Could you please throw some light?
Nothing has moved. Well, I don't know. I mean, if you're talking about the legislation, if that's the question, well, let me say, discretion is the better part of valor. That's all I'd like to say on that.
Okay, let's take another one. So what initiatives, this is from again, Anulekha, she's asking, what initiatives can be taken by various governments to achieve net zero? Your views on ESG?
Well, I saw what down to speak on here, and although I must say I agreed only to speak on Cape Town, but we're here, so why not? Let me just say, I mean, the AWG is probably the most active party on ESG for the leasing and the financing community, and we really are. And something's on our website, and much more is not on our website. But we are in the middle of discussions with parties. Was the question what governments can do or what industry? I didn't. Can you just restate?
No, I think it's a very general question about what do you think the initiative should be in general, you know, to get to net zero by 2050.
Yeah, I mean, this of course we could spend a day on, but I would say I'm more comfortable commenting from a leasing and financing perspective on the question. You know, we all know the types of things that can and can't be done. We all know that we must deal in our industry with the law of physics, and we cannot snap our fingers and expect to see electric aircrafts and use of hydrogen tomorrow. We cannot also snap our fingers and like to see the amount of alternative fuel, SAF fuel, which has net zero emissions over its life cycle. These issues are very, very large, but efforts clearly are rapidly accelerating on the technological side, on the SAF side, on trying to make operations and air navigation more efficient to reduce all those things. We are looking at things really from the question of, and this is the financing side of it, is that there's an increasing amount of pressure on financiers, lenders, investors to allocate or reallocate their capital to ever more green purposes. And the question of how the industry looks at at green concepts and green financing, what the criteria is one of the 2 or 3 most important issues we'll be facing as an industry over the years to come. The action right now is really at the European level. I think many people here have heard about the EU taxonomy on green financing. Even though it's because many of the lenders, Indian lenders and the Indian lessors, are European entities, and so they are subject to this thinking. It looks to where the lessor is, and that the rules will apply to them. And so the question is, how will they assess the operations of the airlines, and what have they done, and what steps will be taking? And we are right in the middle of an absolutely critical discussion, negotiation on that. I would just say that there just will be increasing pressure on the industry to improve, technologically improve emissions through aircraft type, and we're trying to ensure that the transition is done in a way that's not prejudicial to different people in the value chain, and people that have different types of aircraft. So I'll leave it there.
Absolutely.
I'll leave it there.
Yeah, absolutely, Jeffrey. One last very innocent question is, why is there an absence of force majeure in leasing agreements of aviation companies? I know it's not absolutely easy, but I think you just agreed to answer all the questions that are coming up across the seminar.
Yeah. No, it's fair game. Okay, well, since we're going there, let me just say, okay, and I remember, when contracts were a bit different. I think, first of all, for completeness, we might as well put out, if you we're talking about legal concepts or provisions which have been or could be implicated in the COVID context, right? And so, if you took operating leases and loan agreements and purchase agreements, the three things you've been discussing, so far, operating agreements, there are contractual outs for performance. There's the question of force majeure and impossibility, and then there's termination and bankruptcy. That's kind of what we've seen there. Loan agreements, different types of things, and purchase agreements, usually it was material adverse changes and excusable delay and liquidated damage type concepts. The question, since it was on force majeure, I'll put this in the operating lease box because that's probably where it came up. It also, the other related concept is legal impossibility, which is kind of a sister side. But on the core question of, and this came up and Priya said it before, risk allocation in the aviation industry for many years was based upon the concept of a hell or high water clause. Hell and high water clause says, come hell or high water, come COVID or anything else, payment is made, rather than a force majeure clause, which says the opposite. Now, the industry could have developed another way, and theoretically it could develop another way, but there are great costs associated with that. I think it's easy to say we'd like a force majeure clause, but many things would follow from that. Many adverse things would follow from that to the airlines. When I hear comments, it's almost as, well, that's just something we want. It wouldn't be that simple. It's the whole structure of the economics of the industry, which is that the allocation, with very few, has been made in the contract, and that is the basis of it, and then that permits the renegotiation. And then if the airline, of course, can file bankruptcy, and that changes the bargaining power, and bankruptcy law with alternative A, produces outcomes. But to just sort of say, tomorrow there should be a force majeure clause, I think that is, I'm not surprised what the 10 lessors who spoke to Priya said, because it's so fundamental to the basic economics. I would just point out one other thing, which AWG has done a lot of work on. Some countries have made a parallel argument about Cape Town and said, force majeure, we don't have to follow Cape Town. Things are, when we ratified the treaty, we didn't expect this. I know we have an obligation, but gosh, things are difficult now. We don't want to follow our treaty obligation. It's the same idea, same logic. And of course, we've taken great issue with that. And I think international law does not permit the concept, because when people are entering these fundamental things, the idea is a predictability-based system. I think that, when you look at what happened in India, I think it's worked out very well. It's really worked out remarkably well, considering the severity of the situation. And I think that certainty, the predictability, the commercial predictability, has been the backbone of the ability to work things out.
Absolutely, agree. Yes, and I think like Priya was mentioning, and like you just covered, the commercial predictability, and to be able to connect and work together in the value chain to be able to make it work. Thank you, Jeffrey. This has been very insightful, incredible. I can't thank you enough to be on this session. Like I said, it would have been incomplete without your participation.
My pleasure. Thank you very much. Thank you all very much.
Thank you. With that, we would like to move on to the release of our handbook on aviation, and I would like Atul sir, who is the managing partner of our firm, to release this handbook on which we have been working for a very long time. We have tried to put together and try to give a broad direction in what a leasing an aircraft, a leasing transaction entails from an Indian perspective, and how does that journey look like, and the current key trends that, in our view, will have a lasting impact on the leasing transactions. So the floor is yours, sir.
Thank you, Neha. Thank you, Kashish. Thank you, everybody who has been involved in this workshop. Of course, I'll take the credit of cutting the ribbon, as they say. But ultimately, it is all your effort, the effort of each and every colleague at Link Legal, which has gone into creating this handbook. We have talked about different topics. We have talked about acquisition of aircraft. We've talked about leasing. We've talked about the conventions. We talked about the Indian regime, and we have talked, much more than what is contained in this handbook. So this is only a minuscule part of the knowledge that we have been trying to collate and share with students. So this will be only one aspect of what we have covered in the workshop. And I hope that we can come out with similar handbooks on all the topics that we have covered and share it for the benefit of students and the industry and the consultants across the industry. But it has been a wonderful experience to sit through and be a part of this workshop. A very big thanks to Neha, Kashish, Anand, everybody who has been a part of it. And of course, all invitees who have been a part of this workshop, including, I would personally like to thank Mrs. Agarwal, then of course, Dr. Reddy, Stephen, Jeffrey, Richard, and Priya, and of course our own colleagues and the Campus Law Center who have contributed to this workshop. And hopefully we would moving forward, we will engage much more with the Faculty of Law, because I personally feel so, it's that relationship which has prompted us to join hands with the Campus Law Center. My father studied in the Campus Law Center. I studied in the Campus Law Center, and both my sons have studied in the Campus Law Center. We're all products of the Campus Law Center, and I think we of course, when my father must have passed out, there was only one Faculty of Law. There was no centers, but we have all been products of the same college and law faculty and the Delhi University. So we always felt that it was very special to have a session with them for their students, because it is time that we, as the alumni, start contributing towards, really upgrading the skills of students at the center, because in some ways, we feel a little left behind, because after the introduction of the 5-year course, there has been, of course, I'm personally a big votary of a 3-year course, but I hope that we can really contribute in future to the knowledge and professional growth of students at the Campus Law Center. So I'll hand you back, Neha, and thank you so much for anchoring this, Kashish, Neha, and of course everybody from Link Legal and the Faculty of Law and all invitees once again.
Thank you, sir. I have to reiterate that we as a Link Legal family were extremely proud to do this, and this wouldn't have been possible without the support that we got from leadership. You yourself have been participating in this, giving us the right kind of direction. So I think it was only with your views and your inputs that we could make it possible. So thank you so much, sir.
Thank you so much, sir. I mean, I think we need to go back to the source, and that is you. That's where the idea came from. And
Yes.
I think, apart from, of course, we've had chances of learning from you, but these events give us, the idea of giving back to the students, and with learning, I think that is most important. And thank you for that, sir. Thank you so much.
And of course, a special mention of Mrs. Alka Chawla and Seemaji for, really, being, we are encouraging this initiative.
Absolutely. Thank you, sir.
Thank you.
With that, I would also like to call on Dr. Seema Singh to give the vote of thanks. Dr. Seema Singh is LLB and LLM from Lucknow University and PhD from Jamia Millia Islamia, Delhi. Her doctoral research is on the scope of science in India. She has experience of teaching LLB, LLM, and PhD students, and her special area of interest is constitutional law, comparative constitutional law, international economic law, administrative law, criminal law, and jurisprudence. She has authored and edited 3 books: Law and Spirituality Exploring the Bond, Reflections on Ancient Indian Jurisprudence in the Current Social and Judicial Setup, and Nagarikta Sanshodhan Adhiniyam Tathyavam Satya Ek Bauddhik Vimarsh. She is also known for her work as social political legal analyst on different forums. As an activist, she has been a part of various PIOs against WhatsApp, Netflix, and farmers' suicides. As a co-director, she has submitted her report on agrarian issues and plight of farmers. In August 2021 to ICSSR, she has been awarded by Srimati Kamal Sharma Award for Academic Excellence in 2021 by the Lexicon Group. She is also nominated by Honorable Governor and Chancellor of Raj Rishi University, Alwar, Rajasthan, as member of Academic Council. Over the past few months, I've had a chance to work very closely with Dr. Singh, and I must say she is one of the most driven and committed academic that I have come to know. Her contribution to the field of law and the growth of students is commendable. It was an immense learning experience for me, and it is my pleasure to invite Dr. Singh to give the closing address. It's over to you, ma'am.
Thank you so much, Neha. Thank you. It was truly a very insightful and I will say a mind-boggling workshop for me. And we have discussed different areas related with the aviation laws, which are very unexplored areas of now, especially in the field of legal academy, I would say. So I was just thinking that whenever we board in the aircraft, we never realize that so many legislations are working, working in this particular sector. And in this 2 days journey, obviously there are several issues which have been discussed. And I would like to sum up quickly, with some whatever have been discussed by the different speakers in this workshop. Like in the day first, I will begin from day first. Mr. Ambar Dubey, Joint Secretary, Minister of Civil Aviation, he has raised very valid point. And these days lots of discussion is going on about the drones. So he has discussed the importance and benefits of the drones. And the best part of this 2 days workshop is that how much is the potential of this aviation sector in India, because it is a very upcoming market. So that is something which is very, very, very important. And I think after this workshop, not only the legal academia and the students, but several other people are also going to think very seriously about, this potential of the market in the aviation sector in India. So obviously the drone sector, which was raised by and discussed by Mr. Ambar Dubey and Ms. Vandana, she has discussed the hefty increase in the percentage of domestic air passengers owing to the rapid and unprecedented growth of the aviation industry in this period. And obviously during the period of the COVID, because the entire aviation industry has faced a crisis. And I have seen that few of you have also discussed the same. So, India has a great potential, and Ms. Vandana has discussed all these things. And obviously Atul Sharma sir, and sir, there is good news for you that very soon we are going to launch a 5-year program on the behalf of the Faculty of Law, and we are going to plan to open a few new centers also in the different part of the Delhi. So that, because here many of you are from the CLC, so I think it can be a good time to announce this thing and share this information to all of you. So Mr. Sharma explained in detail about the history of the aviation laws, internationally, and also how Indian aviation laws were evolved. This is something which is very much important. He began with evolution of Aircraft Act and corresponding aircraft rules in India. And this was followed by a discussion on the emergence of the Chicago Convention, which further led to the formation of International Civil Aviation Organization. Then the next speaker was Mr. Balakrishna Reddy. Mr. Reddy encapsulated the international air law into 3 Ps, and all these 3 Ps are very, very, very important: public air law, private air law, and penal air laws. Navigating the discussion to private air law, Professor Reddy referred to the private air laws as the Warsaw regime system, where the Warsaw Convention forms its foundation. So that was very informative on the part of Mr. Reddy. And then Professor Stephen, obviously he discussed how basically this aviation industry started growing after the World War II. The US government, seeing the end of the World War II, invited delegates from again around the world to Chicago this time to put together a new content and a new convention. So thank you, Mr. Stephen. And on the second day, I joined a little bit late, but yes, of course, the first speaker was Mr. Richard, and he threw light upon the aircraft leasing, and he touched the different dimension of aircraft leasing, wherein he differentiated between the dry lease and the wet lease. Mr. Anand Srivastava, he gave us an industrial overall view about the aircraft industry and introduced to providing a snapshot of the draft purchase and 4 steps of aircraft contest. Then Ms. Namita Das. Ms. Namita Das, she has delivered process of aircraft and price documentation and purchasing process, certification processes, purchase documentation, and many other parts which are involved in the entire process. And then Ms. Priya Mehra, the lease agreement with the lessor, risk involved in any such pandemic condition, risk involved on the part of the manufacturer, lessor, as well as of the lessee. And then yes, the value of the mutual trust during such unprecedented situation. This was a very important takeaway point on the part of Ms. Priya. And then Mr. Jeffrey, obviously here discussed the Cape Town Convention and how to balance the conflicting interests and how to resolve the problem of obtaining certain and opposable rights to high valuable aviation assets, and obviously the CTC in India, and few questions have been asked regarding the same. So with this, this was all the concluding points, the takeaway points, and obviously in the future, we are looking forward, as Mr. Atul Sharma has said, that in the future, we are looking forward for such more ventures, and we will definitely organize some more programs. And I would like to especially thank Link Legal, the entire team of Link Legal, Mr. Atul Sharma, Neha, Kashish, Farah, Manju, and Abhinav Garg from AILSF. They all have contributed Abhinav has contributed his very valuable time with us. Kajal, Vijay, Sneha, Charvi Virmani, Nikita, Sanstuti, and Vakula from DDS, and all the attendees who have joined us for these 2 days. And it was a good strength, and I am very much happy that we can say, or we can claim, that it was a very successful workshop. So for successfully organizing this workshop, I again, on the behalf of the Campus Law Center and my professor in charge, Professor Arka Chawla, I extend my congratulations to all of us and all of you. And obviously, we are going to plan to organize something more on some specialized topic of the aviation law, and for that we will discuss further. So with this, big thanks once again to all of you from my side. Thank you so much.
Thank you, ma'am.
Yeah, you would like to close?
I would like to, thank you. I would like to thank every student and every attendee and every professional who has been a part of this journey. We took this initiative to do this with Campus Law Center because, just like Atul sir mentioned, we have a relationship, we have a long-standing relationship with Campus Law Center. Very many members of our firm, families are from this institute. So we have a relationship that we want to carry forward, and we would like to do multiple such sessions going forward. Hopefully, we have been able to bring to you some insight into what really goes into aviation. That you see that aviation is developing into something which is very big in the Indian context. The economy is growing, so is aviation. In the next 20 years, we are going to see immense growth in terms of potential. Therefore, skilling is extremely important. And when we speak of skilling, we have to speak of lawyers. We are those pioneer important people that, like we discussed across this session, there are multiple agreements that go into making an aircraft leasing possible. And there is a huge value chain which needs you at every single step. And if we are not prepared, we'll find ourselves lacking at multiple places and will not be able to support our country, ourselves, and our economy when it's needed the most. So that way, I hope we have been able to bring you some insight into where we are going, what we are doing, and thank you so much for joining us once again. And yes, like as we discussed yesterday multiple times, Kashish also reminded you today that certificates will be issued to students who have participated and registered. And the link to the feedback form is in the chat box right here, and we'll hold up the screen for some time, for 10 minutes, even after the speakers log off. So thank you so much for joining, all the attendees, all the participants, everybody, CLC and Atul sir, Kashish, everybody on the call. Thank you so very much.